Page 1, item 7.
Wait, we are just reaching there.
For tomorrow. On behalf of Mr. Rao, has some difficulty.
Let us see that. Just wait.
Item 9 permitted to withdraw.
Withdraw.
9.
Weekly list item number 1.
Wait, please, Your Lordship. And the petitioner here is the mother of the victim girl, my lord. The victim girl, the daughter of the petitioner, aged about 15 years and 6 months, was kidnapped by one Sanjay Kumar Sendo. The FIR was lodged on 28/9/2023, and the victim girl has not been recovered till date, my lord.
Yes. Any instruction you have received or
No, first time.
First time. Well, I take instruction about this writ petition in the nature of habeas corpus has been filed by the petitioner for a direction to the opposite parties number 2 and 3 to produce the missing daughter of the petitioner, who is stated to be minor. The Learning Council for the petitioner submitted that petitioner herself lost the first information report in connection with the kidnapping of her daughter by opposite party number 4 before the inspector in charge of Kamakhya police station on 28/9/2023, on the basis of which Kamakhya PS case number 448 dated 28/9/2023 was registered under section 363 of the Indian Penal Code. And till date, she has not received any response from the investigating agency about the whereabouts of the daughter. The Land Council for the state has received the copy of the writ petition and seeks some time to obtain instruction not only about the progress of the investigation, but also the steps taken by the investigating officer for rescue of the victim girl. So also the apprehension of the opposite party number 4. I'll put up this matter as well. 4th December 2023, pre-copy of the order be handed over to the Learning Council for the state for compliance.
Item 2.
But petitioner is the father of the victim girl, who is less than 15 years old while she was coming from school pursuing 10th class. She was kidnapped by the OP number 4 and others. Annexure 1 is the date of birth and Annexure 2 is the FIR. And those cases
when you lost the FIR, 22/8/2023.
My lord, till that my lord, no recovery.
And your daughter's age is
my lord, less than 15 years.
Date of birth is, my lord,
19/4/2009.
All right. It's a fresh matter, so take instruction. ये लिखिए है ना, ये मदर जगह फादर कर देवे है ना, बाकी डेट ऑफ एफआईआर टाइप ये करी कि ऐसे उनजे आइडिया पर लिखियो कौन सा ना, सेम डेट ऑफ वीक ऑफ yes. Next.
Item 3.
Next. My lord, the minor girl has been kidnapped on dated 3/10/2023, my lord. Thereafter, the mother of the victim lost the affair on 5/10/2023. Till that, the police has not taken any action, my lord. 16 years.
Just a minute. earlier some orders were passed in this case. এটা কোন এটা তুমি বার করছো 149 of 2023 কাই
Lily, who is the petitioner?
এটা কোন এটা এই যে ଅଛି ତ ହଁ ସେଇଟାରେ ମେନଟାରେ ନାହିଁ এটা ଡାଇରେକ୍ଟ ଖୋଲୁଛି so it's a fresh matter so you have lost the FIR under annexure
Mr. 1, my lord.
annexure 1
My lord.
date is 5/10/23
5/10/23, my lord.
and the petitioner is the informant in that case Kabita Malik,
Kavita Malik, the mother of the victim.
mother of the victim. What is the age of the victim?
My lord, 16 years.
16.
Annexure 2.
39/7 madam.
30, my lord.
15-16 हाँ मैंने अच्छा इंस्पेक्टर इन चार्ज ऑफ वासुदेवपुर पुलिस स्टेशन ऑलराइट सही टाइप को लिख दो ऑलराइट सेम डेट इट विल कम
Madam.
Item 4.
May I please your my lord. There is a stamp reporting that leave to appeal is to file
what is this criminal appeal for
against the judgment of acquittal.
हाँ
SC/ST Act was there. Offence was initial 302 my lord.
just a minute what is the impugned judgment okay it arises out of a PS case na
My lord. And the appellant before your lordship is the mother of the deceased.
okay talking to the part scene may kindly be seen हम्म अच्छा oh he was the trial judge अच्छा अच्छा okay I'm reporting he at flag B may kindly be seen on the closing CRLLP. Why CRLLP? 14 year तो जो उठी होगा 372 रे हायर कोर्ट को जीवो ना 14 year का देखिए ये था SC/ST था देखिए थ्री 372 था दियो notwithstanding anything contained in the code of criminal and appeals are live from the judgment sentence order will not be an interlocutor order of a special court exclusive special court to the High Court and both on times so it's clear then 370
My lords, may I have a glance to the section 14A of the SC/ST bill?
No, that is already.
Clear. The victim is why he has pointed out that leave petition will be नहीं काहेंगे लीव क्यों फैलो तो अपील फैलो ना डायरेक्ट चीज नहीं नहीं लीव टा केवल 378 रे लीव करता है 74,
Yeah,
that's a complaint case type.
Oh, it's a direct.
Direct, other 14 reduce section.
228
All right. The stamp reporter has pointed out, this criminal appeal has been filed under section 14A bracket 1 of the Scheduled Caste Scheduled Tribe Prevention of Atrocities Act 1989, reduced section 372 of CRPC, challenging the judgment and order dated 23/2/2017 passed by the Learned Special Judge Kendrapada in acquitting the respondents of charges under section 452, 294, 354, 384, 302 of the Indian Penal Code, section 31X of the SC and ST PO Act, reduced section 34 of the Indian Penal Code. The petitioner, the appellant, Amulya Malik, is the mother of the deceased, Sukanta Malik,
Sukanta Malik.
and she is the informant in this case. Who is that? Whether she is the informant?
No.
No.
Then
My
she,
informant is the mother of the deceased will actually. Informant is the
Informant,
mother.
yes,
Yes, yes.
Karatu.
so and so, one so and so. The fact code लिखा है जी.
Karatu re
Informant is the mother of
अच्छा. Now we just want to know what. Let us see that so her evidence has been discussed as who that name is Nahala Amulya Malik. Okay. Amulya Malik is examined as PW 5. All right. Her evidence has been discussed in paragraph number 13. No, the informant come PW 6 is the Arun Kumar. So informant is PW 6, not PW 5. This Amulya Malik. That is page number 14. The informant come PW 6 Arun Kumar Malik has testified. So informant is PW Swanso is the victim in this case, and she has by Swan. The section 3, section 14A reads as 14A1 reads as follows. (14A and 2) you quote it. Section 372 of CRPC the proviso to section 372 CRPC reads as follows. For the proviso portion 372 लिख दे छक्की छक्की मारिगिन proviso ऊपर. In view of section 14A of 1989 Act, read with section 372 of the CRPC, it is very clear that against the impugned judgment and order of acquittal passed by the Learned Trial Court, the victim, that is the mother of the deceased, has a right to prefer this appeal, and accordingly he has preferred this criminal appeal. Therefore, the objection raised by the stamp reporter that nomenclature is not correctly furnished and the correct nomenclature may be CRLLP is not correct. This CRLA is maintainable. The stamp reporter should accordingly make the stamp reporting and place the matter. And thereafter the matter shall be placed in the week commencing from 28th November 2023. Okay.
Item 5.
Item 5, my lord, I am for the opposite party. The petitioner has filed for extension of time to conclude the inquiry report. Now, order was granted 6 weeks time to conclude the inquiry. In the meantime, inquiry has been concluded. So, no further extension may be required.
Oh, this is a disposed of case.
Extension of time is okay.
Thank you. What for? What for?
Kiye extension of time kiye pagijandi.
Petitioner.
No, as such it is infructuous.
Yes, madam. In the meantime,
We just directed in the concluding part that accordingly we dispose of this writ petition with a direction to the government to complete the inquiry within a period of 6 weeks from today, after giving due opportunity of hearing to the respective parties and thereafter take appropriate steps in accordance with law. So that order was passed on 4/12/2018.
my lord.
And almost 5 years is going to be
In
elapsed.
the meantime, inquiry has been completed.
Inquiry has been completed. So this
Seven-
IA has been filed for 3789.
Copy notes of so.
Okay, IA number 3789. This application has been filed by the state for grant of 3 months further time to comply the order dated 4/12/2018 of this court. The writ petition was filed by the petitioner seeking for a direction to restrain the opposite party number 3, Professor Dr. Datteswar Hota, from continuing to act as HOD Urology, SCB Medical College and Hospital, Cuttack, and not to entrust the opposite party number 3 with any examination related matters of the procedure. Opposite party number 3 lekhantu Sumit Kumar Panda. The writ petition was disposed of on 4/12/2018 with a direction to the government to complete the inquiry within a period of 6 weeks from the date of pronouncement of the order, after giving due opportunity of hearing to the respective parties and thereafter to take appropriate steps in accordance with law. And the interim order dated 17/5/2018 stood vacated. The London Council for the opposite party submitted that in the meantime, inquiry has already been completed and he has furnished the inquiry report. So also the consequential order passed by the government. Where is that inquiry report? अच्छा
order
अच्छा
टा
ठीक है on inquiry अच्छा order inquiry report टा काटी दियंतु. Order dated 29/38/2019 of the government of Orissa Health and Family Welfare Department, where it is indicated that the inquiry has been completed. In view of such state of affairs, this interim application has become infructuous and accordingly disposed of.
My lord, I am appearing on behalf of Mr. Prafullo Kumar Rakhana.
Yes.
अच्छा कहाँ पे ये को opposite party?
Opposite party number 3, my lord.
3.
अच्छा
My lord.
opposite party number 3 कर दिया तो move पहले है ना produce this है ना I disposed of thing infructuous and disposed.
Item 6.
May I
Item
please, your
six,
lordship?
I am
Here
for
I am
the
for the
oppo-
counsel for the petitioner, my lord.
I am for opposite party.
Yes,
to
the
VC, my lord.
dispose of case, my lord. Lordship,
Yes.
may kindly peruse the order dated 9th January 2020, my lord.
This interim application has been filed
After disposal of this city application, I had filed the IN number 275220 for extension of time. And also my friend Mr. Balkrishnan, he had filed a IN number 567 of 2020. In the meantime, as for the direction of this honorable court, I have already repaid the entire loan amount to the bank.
Okay.
The month
So
of
it has become
December 20, he has
No
paid.
extension is
No, nothing
No.
required. It has become
it has
infructuous.
become infructuous. Yes,
Yes,
Mr.
ma'am.
Oh, all right.
It has become
Uh,
infructuous.
Okay. This IA number 567 of 2020 IN number 27 so and so dita ko kar diya
2752.
2752 of 2020. This writ petition was filed by the petitioner seeking for a direction to the opposite party number 1 authorized officer IDBI Bank to allow them some time to repay the loan amount under OTS after deduction of the amount which has already been paid to the bank in respect of the loan account number so and so. Lekhaiji order dated 9/1/2020. This court filed order dated 9/1/2020 dispose of the writ petition with the direction that in case the petitioners deposit a sum say operative percentage lekhaiji likhi do. The interim application sub para 567 of 2020 has been filed by the opposite parties
1 and 2.
1 and 2 for modification oblique correction of subparagraph 2 of the order as plus interest and expenses or be corrected as rupees 21,42,822 as on 882 as on 9/1/2020 and IN number 2752 of 2020 has been filed by the petitioners for extension of 1 month time to deposit the rest of the amount. The London Council for both the parties submit that in the meantime,
The matter already the entire amount has been paid
Acha.
by the petitioner to the bank.
entire amount has been paid by the
And entire
petitioners.
settled amount to the tune of 19 lakhs odd. In the month of December, it has paid.
December
20.
2022, Mr.
2020.
Acha, 2020, all right. December 2020. The entire amount which is which was due to the petitioners already been paid in December 2020. The London Council, Mr. Balkrishnan Land Council appearing for the opposite parties, number 1 and 2, na?
1 and 2.
1 and 2 has also not disputed the same. In view of such submission made by the respective parties, both the interim application has become infructuous and accordingly disposed of. Yes.
Obliged.
Item 7.
A big part of balance.
Please use the mic properly.
Balance. Due to sudden demise of my Learned Senior Mr. S.S. Rao's close friend of him, he had to leave my lords. So what I pray is your lordship may take up the matter tomorrow.
Tomorrow you want.
My lords.
Already it is there in the weekly list. It will be called tomorrow.
Grateful.
Okay. So it is on 21st, 12, 2020. Yes.
Item 8.
Five 21. What is this matter, Mr. Tripathi?
It's a kidnap of a minor guardian lordship.
This matter.
Yes, sir.
Race matter?
No, no. 2020 matter.
हाँ, कौन है
What was
लाभ?
the earlier order?
But I tried to contact that ISC Tigriya Mela. Couldn't able to contact him.
No, the order was passed from time to time, and the last order seems to have been passed on 22/4/2021. So thereafter this matter was not listed. Now kichi achi order dekhilo 22/4/2021 ପରେ ଆଉ କିଛି order ହେଇଛି କି? नहीं. अच्छा. The victim girl is the minor daughter of the petitioner.
Right.
Okay. What is your instruction? Has she been rescued or
I tried to contact the
contact the IIC Tigriya police station? No,
Tomorrow.
this is in the weekly list. We can keep it to
Yes,
tomorrow. You
tomorrow.
take instruction.
That I did.
All right. এটা কালি কি ডাকিব weekly list to 21/12/2023. Yes,
Item 10,
Mr. Jyotirmoy Sahu. Yes, what is this matter, Mr. Tripathi?
Here also, my lord, the victim girl has been kidnapped, and now his case is with the ISC Nachuni.
IAC
Nachuni.
Nachuni.
My lord.
The last order was passed on 17/4/2023. Now what is দেখুন S.K. Patnaik, London Council, appearing for the petitioner, has expressed his serious concern about the way the police has been conducting the search for recovery of the victim girl. In terms of her direction as reflected in the order dated 27/3/2023, Mr. J. Katkial and an additional government advocate appearing for the state has produced the fresh status report. We have perused the status report and found that the police is in possession of the accused mobile number, despite that the police has failed to locate where the accused has taken away the victim girl. Is unfortunate in so and so we direct also to take action by the this matter. Okay, any development made? You are the
IIC of National Police, madam.
okay. IAC of which police
Nachuni
station? Nachuni police station.
Initially, the case was lodged at Banpur, my lord,
Banpur.
but now segregated.
In view of the jurisdiction, it was taken back. So since when it has come to this Nachuni police station?
In the month of August
August of 2022.
23.
2023. The FIR is dated
FIR dated 12/9/2020.
12/9/2020. So what is the development made after it has come to that? You have submitted the status report, okay? I see that basing on so it was registered during course of investigation. Previous I have promptly visited the spot, seized so and so. Okay. Oh, minor girl was just 13 years.
Yes, madam.
Now she must be 16 years and some months. The victim was charged in the so and so and that person has been named in the FIR as the accused. Okay, Samir Naik.
Yes.
He is opposite party number. You have not made her him as the opposite party.
No, ma'am.
Why? If your allegation is that he has kidnapped, so it is to be rescued from him. He has a right to be heard in this matter. Obtained the whereabouts of the victim as well as unfailed in that according to some neighbors once of the accused. Thoroughly with no man missing registration. Verified. The villagers of the accused were working outside the village once have been examined. So give him a copy of this report to Mr. Sahu.
My
He has a
lord.
right to go through it.
My lord.
What you are doing. So you have sought for more time.
My lord.
Mr. Sahu,
Yes,
you just add that person as an opposite
Yes.
party. That accused whose name is Samir Naik, right? And the father's name, everything you have given in the FIR. Mention that. He is missing for more than 3 years and you are unable to trace it out. This accused is not there in the house, nor in family members are not telling anything about that mobile phone is switched off. That mobile phone of that accused. And there is no bank passbook, etc. Your client has also not received any information.
No.
Any phone call, any
No.
friend of the victim.
No.
What that boy was doing?
Any information?
ଯିବା ପୂର୍ବରୁ କଣ କରୁଥିଲା?
ସେତେବେଳେ ଲେବର କାମ କରୁଥିଲା ସେ
Oh,
ବାହାରେ।
acha. All right, Mr. Chandrasekhar Jena, IIC Nachoni Police Station is present, and he has filed the status report, which is taken on record. Land counsel for the petitioner seeks permission of this court to implead the FIR named accused Samir Naik as opposite party number 3. Permission is granted. Correction.
Opposite party number 3.
Opposite party number 3. Side signature. After going through the report furnished, it appears that sincere steps have been taken to rescue the victim girl, also to apprehend the accused. But no fruitful result came out. The inspector in charge in the status report, some more time has been sought for rescue of the victim girl and to take follow-up action as per law. Put up this matter. List this matter in the week commencing from 18th December 2023. Mr. Tripathi, masse upper upon pouch and the mas pakapagi, so you get it. So, Mr. IAC, you remain present on that day with the up-to-date instruction. Yajitu tapare kon korishandi seta. On the next date, the IAC shall remain present and apprise this court about the development, if any, made in the meantime for rescue of the victim girl. Free copy of the order be handed over to the London Council for the state attorney. Copy. Yes.
Item 11.
Yeah.
My lord, in this case, I am unable to get any instruction, my lord.
Let it be tomorrow because as per my instruction over phone, my lord, already rescued.
Victim?
Tomorrow.
So 21/12/2023.
Item 12.
May I please, my lord? Where, my lord? Kidnapping of a minor girl. Lord.
Already rescued, man.
Already rescued, but my lord, the investigation has not been progressed, my lord.
That's a separate file.
Different cause of action.
You file a separate application for that. We are concerned with the habeas corpus about the this writ petition in the nature of habeas corpus has been filed for a direction to the opposite parties number 2 and 3 for protection of the minor daughter of the petitioner before this court. Today, the Land Council for the state has produced the written instruction received from the IIC Sadar Police Station dated 19/11/2023, from which it appears that the victim girl has already been rescued on 8/9/2023, and her statements have been recorded by the investigating officers, who also by the JMFC City Kendrapada under section 164 CRPC. The written instruction is taken on record. The Land and Council for the petitioner has also not disputed that the victim girl has been rescued. However, he submits that the police is not conducting proper investigation of the case. If the petitioner is aggrieved by the improper investigation, he has to file a separate writ petition, file a appropriate petition before this court. In that respect, after hearing the Land and Council for the respective parties, we find that no further order is required to be passed in this WPCRL, which is accordingly disposed of. Yes.
Obliged.
Item 13.
Yes, Mr. Akshay Biswal. Not there. Eta kon kuhantu?
Last order DNA report call for it.
Last order mane 17/2/2023. Place this matter again on so and so 22 आपरे तार है नहीं 17/2 पर 17/2/2023 19/2 रे खाली 8 जन इतला तापर हो ही नहीं. Okay, learn so and so to produce the DNA test report of the dead body that has been recovered at the instance of the petitioner. None appears for the petitioner so and so. Okay. Is a case under section 302 or what? And perhaps under section 27 of the Evidence Act, skeleton was there, right. But whether that was of the deceased or not, for that you, so what do you find?
Let me give 2 weeks time. I already talked. It is on process.
No, but what is the prayer in this petition? Direct initiate a case against the so-called wife and so on, so respectively, and her family members involved in the missing of the brother. So you have got the case diary also? So no, this FIR was lodged in 2020. We are in 2023, so more than 3 years have passed.
Nobody also appearing on behalf of the.
No, that's a different matter. Just as since it is a 302 matter, and there was a specific direction of this court to produce.
DNA will produce matter 2 weeks time.
No, DNA test alga katha. Maybe that that might have reached in the meantime, or what is the latest stage now? Okay. None appears for the petitioner on 17/2/2023 when the matter was listed, the London additional government advocate was directed to produce the DNA report of the dead body, which was recovered at the instance of the petitioner. Land Council for the state submits that he may be given some further time, not only to obtain the status of the what is this PS case number, Mr. Bonpali PS case number? So you don't know.
10 of 2020. Sorry, that is PS case number, my lord.
You have gone to message MMR man. FIR
DR number, it was 262 of change.
এটা ওটা খালি প্লেন পেপার এফআইআরটা দিয়েছি
তারপরে দেখো ডিএ করছেন কোনে ডিআর নম্বর ডায়েরি নম্বর করি করছেন
ডায়েରୀ ନମ୍ବର ନୁହେଁ ମ ଆପଣଙ୍କର କିଛି ଏଫଆଇଆର କଣ ହେଇନି?
ଏଇ ତ ମାନେ ଲାଷ୍ଟ ଯାହା ଇନଷ୍ଟ୍ରକ୍ସନ ଥିଲା 10 of 2023
PS केस नंबर
ଆଜ୍ଞା
को PS केस ବହରପାଲି
Bonpal. Only in 23.
ହଁ 23 ରେ 302 କେସ୍ ରେଜିଷ୍ଟର
No, the FIR is of the year 2020. মানে written report. Please see it verified.
Let me verify, madam.
এটা হলো BAM Bonpal PS case number.
Because 2020 ଦେଇଥିଲେ ବୋଧେ ତାପରେ ଇନଭେଷ୍ଟିଗେସନ ଥ୍ରୁରେ ଜାଣିଲେ ଯେ ସ୍କେଲିଟନ ହେଇଯାଇଛି ତାପରେ ରେଜିଷ୍ଟର ହେଇଛି କେସ୍ ପିଏସ୍ କେସ୍ ନମ୍ବର ମିସିଂ କେସ୍ ହିସାବରେ ଥିଲା ବର୍ତ୍ତମାନ
ମିସିଂ କେସ୍ ଥିଲା ଯେ ତାପରେ ଆପଣ
ଯାହା ରିପୋର୍ଟ ଏଟା ମୋ ପାଖରେ ଅଛି
ବର୍ତ୍ତମାନ PS କେସ୍ ରେଜିଷ୍ଟର୍ଡ ହେଇଗଲାଣି ସିଓର?
ହଁ ଏଇଟା ଦେଇଛନ୍ତି କାରଣ ସେମାନେ ଯୋଉ DNA ପାଇଁ ଟେଷ୍ଟ ପାଇଁ ପଠେଇଛନ୍ତି
Against PS case.
ହଁ ସେଟା PS କେସ୍ ନମ୍ବର 10 of 2023
10 of 2020
under section 302 201
10 of 2023 302
201
201
ମାଇଲ
34 ଅଛି ନା ନାଇଁ?
34 ଅଛି
34. So you obtain instruction about the London Council for the states submitted on instruction that on the basis of the written report presented by the petitioner Srimati Ambika Patra, Bonpal PS case number 10 of 2023 was registered under section 302(201) by 34 of the Indian Penal Code on
21st 1 2023
21st 01
yes madam
2023
as PS case number 10
Yes.
10 कहले पर
ଆଜ୍ଞା
and he may be given some time to
Banharpalli
अच्छा बहरपाल में
नहीं Banharpal नहीं
Bonharpalli.
Banharpalli
Oh, Jharsuda.
अच्छा
Bonharpalli at
BANHARPALI
है ना बहरपाली ले बहरपाल में है ना
Bonharpalli. In
बहरपाल
the district of Jharsuda.
The Land Council for the state seeks some further time to obtain instruction about the status of the PS case. So also to produce the DNA test report. As prayed for, list this matter. 4 तारीख को 11 तारीख. List this matter on 11th of December 2023. Free copy of the order be handed over to the Land Council for the state.
Item 14.
May I please, Your Lordship?
Last time, one report was produced on
On 6th 11
5th 11/23,
Yes, sir.
and we passed the order on 6th 11/23, right?
IAC
IAC investigating officer Mohammad Jamshed was present on that day, and
We wanted the DCP to hand over the charge to some other officer, not being satisfied with the
IAC Khandagiri.
IAC Khandagiri police station.
And after obtaining the free copy, we sent that my lord, and he started the investigation on 30th.
He is the IAC. What is the name of? Have you brought it?
Abhimanyu Das.
से कौन कॉले तापर अपन केबे इन्वेस्टिगेशन
So they instruct
Sir, 15 तारीख से.
status report has given. Evidently couldn't able to understand my lord the last para of that status report, the investigation he has done after as per direction of honorable.
You took over the charge of investigation on 15/11.
Sir.
Okay. As it appears, after taking over the charge, you examined the informant and some witnesses, and CDR and IMEI of all the mobile numbers and mobile phones were collected, and was analyzed and verified the account numbers of the accused and the family members, so and so, whether there is any transaction made by the family members, but no clue has been obtained. What the accused was doing?
लेबर काम करथले सर.
How to agu ka sunanti? Mike.
लेबर काम करथले सर.
Gio?
Gio टा सर 10th पास करची सर.
नहीं बॉयस के थेला.
बस एबे 18
ହେଇଗଲାଣି 18 कंप्लीट करिगलाଣି. अदा आश्योरेंस दउनांती जति तांको घर लोकंकु पुअर घर लोकंकु जे वर्तमान आसिले किछि असुविधा नाही से साबालिका हेई सरलाणी.
सर मु जाइतली कहि के आसी सर से नाहंती घरे ताला पकई पळी जंती
available in there.
सर
ओहो
से माने रहू नांती गां रे सर.
They have left the place.
तो तांकर गां लोकन सर कहि के आसी 4-5 लोकंकु तापर ता मामू घर को जाइतली सर ता मामू घर को कहि के आसी से माने कहउचंती सर से भी कहउचन से माने जानि चंती सर किंतु जेहेतु तार फादर मदर नाहंती से कहउ नांती किंतु आश्योर करचंती किछि लोक सर जे वेरी सून से माने देबे इन्फॉर्मेशन देबे आ आज प्रोड्यूस करिवल कहउ.
जदि झियो साबालिका ହେଇଗଲାଣି से तो ये करिवो ता इच्छा अनुଯାୟୀ जीव एमानकर झियो घर किछि प्रोटेस्ट करिवार अछि कि
नहीं झियो घर करिवे नै सर.
तां पचारथिले
ता
भी
बापा को पचारथिली से
ताले एते जिंस जदि पाइलाणी तो ए एश्योरेंस ता जदि तांगा बापा मां बा फैमिली मेंबर्स को पाखरे पहुंचेई पारंते
बापा को सर डाकी कहिछि सर तो बापा को से कहउचंती जे थरे सर कथा करै दियंतु. हां झियो संगर थरे कथा करै दियंतु तो
कहार
बाबा तो फादर
झियोर बापा नहीं नहीं झियो संग कथा बार्ता मु कहिए पुअर बापा मां
ताको खबर देई सर से माने मोबाइल एक्चुअली स्विच ऑफ कर दे कि पळी जाइछन सर.
नहीं तांकु जणी सरलेनी जे झियो घर मध्ये किछि आपत्ति नाही जदि पुओ झियो को बाहा हो.
हां सर मु जो जाइथिल कहि के आछि सर तांगर ता मामू घर कहि के आछि सर.
So that is the best way कारण से माने तो जदि से माने जानी थिबे सप्रेस करूथिबे गोटे रीजन पाई जे एप्रिहेंशन रहिछि अरेस्ट हे जिवो किछि आपण जो पीएस केस संक्रांत रे से अक्यूज्ड कि अन्य कोनोसी किसी हाई कोर्ट रे किसी एंटीसिपेटरी बेल बा अन्य एप्लीकेशन किसी फाइल हेलानी
ସେମାନେ ବେଲ୍ ହେଇଛନ୍ତି sir।
कार फाइल
ତ ଫାଦର ମଦର ହେରିକା କୋର୍ଟରେ ଆपिୟର
नहीं
କରି
पिला
parents.
पिला
Parents.
पिला
ନାଇଁ ପିଲାର ହେଇନି
आसीनी अप्रोच
ପିଲ୍ ନାଇଁ ହେଇନି sir।
No, Lordship, it is filed.
ये
Pillar
it is filed,
filed,
but
no
it has not been listed.
no the accused has already filed that petition.
Yes, Lordship. At
Okay.
a time, both the father, mother, and the another strangers.
So one anticipatory bail application was filed for all.
No, Lordship.
Then
Father, mother in one application, 3 strangers and in another application, and
no, please tell us that this main person, what is the name of that boy?
ଲକ୍ଷ୍ମୀଧର ବାରିକ
Barik.
into alias ଲକ୍ଷ୍ମୀଧର ବାରିକ
Lakshmidhar Barik.
sir।
So what is the ABLAPL number? ଆପଣ ପାଖକୁ ଯାଇଥିବ ନା କେସ୍ ଡାଏରୀ କଲ୍ ଫର ହଉଥିବ ଆଜି ଯାଇନି କଲ୍ ଫର ହେଇନି
ନାଇଁ sir, ଏବେ ଆଉ କିଛି ହେଇନି sir।
Can you tell me, Mr. What is the PS case number at least?
95
Khandagiri.
95 sir।
Khandagiri.
22
95.
2025.
हाँ कौन ABLAPL?
No, Lordship. PS case number 95.
PS case नाम ABLAPL को जा हम अपन लक्ष्मीधर बारिक रो ABLAPL नंबर पचाऊ एटा मारदल लक्ष्मीधर बारिक बोली सर्च कलो
केस केस मारदेले आसु
हाँ मुझे
95
केस स्टेटस मारा हाँ
एक नंबर
हाँ ठीक है पार्टी नारे मारा हमारा ये जो लक्ष्मीधर बारिक BARIK हाँ ये ईयर टा होची 2022 रा अच्छा तो 22 रा देखी तो पर 23 रा देख दो যদি এতে বর্ষ করনথিব এফআইআর কেবে রেজিস্টার্ড হইছি হ্যাঁ 22/2/2022 রা তাহলে
ABLPL 2470
আসিওলা
2470
23 ର ବାହାର କର 23 ହଁ କେତେ କେତେ କହୁଛନ୍ତି
ABLPL 2470 of
ଏରୁର ସେ ନମ୍ବରଟା ବାହାର କର 2470
of 2022
ବାହାର କର 2470 2022 ଦେଖିଦବା ଲକ୍ଷ୍ମୀଧର ବାରିକ
already disposed of.
ଚିନ୍ତୁଆ ଦେଖୁ
Withdrawn.
disposed of 9th March 2023 order ତାରିଖ
Withdraw.
हाँ
dismiss as withdrawn.
view Party council for the Viswana for withdraw acha all right so yes withdrawn so you just carry forward with your investigation and that assurance try to give because you have already collected information from the family members of the victim girl that they have no objection if the boy and girl marry each other, right?
But he will believe because of the time at the time of kidnapping he was minor. Even if they assure that.
No, that's a different matter. Agar rescue he because they may file also a 482 application for quashing these. Say, Lekhantu, you are Mr. Abhimanyu Das, na? Mr. Abhimanyu Das, IIC of Khandagiri Police Station, is present and he has furnished the status report dated 19/11/2023, from which it appears that after taking over the charge of investigation on 15/11/2023, as per order of this court dated 6/11/2023, he has examined number of witnesses and also collected the CDS and IMEI of the mobile numbers and mobile phones and analyzed the same and also verified the account numbers of the accused and the family members to verify whether there was any transaction made by the accused Lakshmindar Bari. It was made with the accused Lakshmindar Bari by the family members, but no clue was obtained, and spies have been engaged to work out the clue about the victim and the accused persons for their early rescue and apprehension. The London Council, the investigating officer submitted that now the victim has become major, and he has collected information from the family members of the victim girl that they have no objection if the victim is rescued and she married the accused Lakshmindar Bari, and he has also communicated this information to the family members of the accused. It has been brought to the notice of this court by the London Council for the state that the main accused Lakshmindar Bari has approached this court for anticipatory bail in connection with the case by ABL-APL number 2470 of 2022, 2470 of 2022, but the same was dismissed as withdrawn as per order dated 9/3/2023. The status report is taken on record. After hearing the Land Council for the state, so also the IAC of Khandagiri Police Station with the investigating officer, we grant some more time for further investigation. List this matter in the week commencing from 18th. All right, 18th of December 2023. aka
communicated to the uncle of the accused to inform the parents.
Acha.
Because they are direct not
Okay, say you and he has already communicated or communicated to the uncle of the accused, main accused, for onward communication to the parents of the accused, main accused. 18th of December 2023, the IAC shall remain present with up-to-date instruction. 3 copy of the order be handed over to the Land Council for the state. এটা কেত নম্বর আচ্ছা সি appear করতে পরা non appears করিবেন Mr. Roth appears to the virtual mode করে দেবে না yes 18/12/2020 yes
Item 15.
My pleasure, Lordship. My lord, pursuant to the order dated 28/7/23, my lord, the proceeding for mediation was initiated, and subsequently the mediation has been failed, my lord. And the last date, my lord, I have filed one affidavit. Yes, my lord. Stating all the things, my lord.
London Council for the petition submitted that today he has filed an affidavit along with some documents before the registry after serving copy thereof on the London Council for the state, and he undertakes to serve the same on the London Council for the opposite parties number 1 to 3 during course of this week and prays for an adjournment. So what is this prayer in this writ petition?
My lord, now as per the Supreme Court judgment, I will pursue my remedy, my lord, in the appropriate forum. So in addition to that, my lord, my submission was that, my lord, for the education of my child in the better school, I have given in my affidavit, my lord, the paragraph 12, my lord.
No, the petitioner is the husband of opposite party number 3, right?
My lord.
They are blessed with how many children?
One child. One child.
One child mane kaun?
Male child.
Male child. Oh, that young boy has also been added as a party. All right. So opposite party number 6, Vartaman, he is now staying in the company of the mother, right? So the remedy lies elsewhere. So you are to approach this court because of this decision of the
And in the meantime, my lord, the CP 9 for restitution conjugal rights has been allowed by the London Family Court. CP number 90 of 2020, my lord.
90?
CP number 90 of 2020. 2020.
Acha.
It was allowed, my lord.
That was filed by the petitioner.
Petitioner.
Okay. Now see, in spite of the order that was disposed of on?
Disposed of in last month, my lord.
Okay. Then
2 months granted by the London Family Court, my
lord. For the time to join.
My lord.
Okay. She has not joined your company.
My lord. Yes, sir.
Okay.
And in the meantime, your lordship, the affidavit I have stated, and in the mediation center also, I have given all the reasonable opportunity. I have stated, and without all things that matter has been, the wife is not unable to come to this.
No, it's all right. Now, if you claim guardianship, and the duty of the court is to see that where the best interest of the child would be served in which company, that is to be adjudicated in a different proceeding. So, why is now the entertaining this writ petition for habeas corpus?
Habeas corpus has
filed. Not been illegally. Child is staying in the company of his mother, right?
Sir, and my submission is, I have filed the present habeas corpus because my wife was time and again you're talking with me that opposite partner 1 and 2. The father-in-law, mother-in-law was giving the hindrances. I have stated what I my
whatever it may be. Once you file that petition before the appropriate court, you can file also an interim application to have the visiting rights that can be granted by that competent court. So what further you want? We find that at this stage there is no material before us that your child has been illegally detained or wrongfully confined by your wife in her father's place.
My submission, my lord, with regarding I am answering, my lord, that when we were talking term, I was also paying the monthly maintenance, monthly amount, not maintenance have been granted any court of law. I am on my own motion, I am paying to my child and my wife, and in spite of that, just a minute, in spite of fact that when I am paying the amount, my wife was telling that time, my lord, by that time, that my father and mother was making the hindrances, my lord. Now when she come to this court, my lord,
the scope of this writ petition is very limited.
My lord.
So you avail the other.
Well, I will approach by the as per the remedy, and your lordship may say in this WPCRL, my lord, that my visiting right so also.
No. Sorry. That is to be adjudicated by
in all cases, my lord, in similar cases, my lord, it might be
No.
The court has granted, my lord.
This will be going beyond that the scope of this habeas corpus writ petition. If we'll adjudicate that, then what left to the other court who is to adjudicate ultimately that who is entitled to be guardian of that child and whether the other person will have the visiting rights or not. If everything we decide, then why that forum is there?
My small prayer, my lord. My small prayer is, my lord, I will approach before the appropriate forum.
All right.
And the second prayer is, my lord, that it is open to the opposite partner 3 and 1 to take care of the child for better education.
The writ petition has been filed by the petitioner Ramesh Kumar Sahu with a prayer for a direction to the opposite parties number 4 and 5 to rescue opposite party number 6 from the custody of opposite party number 1 and 2 and to hand over the opposite party number 6 to him. There is no dispute that the opposite party number 3 is the wife of the petitioner, and opposite party number 6 is their son, and the opposite party number 6 is now staying in the company of opposite party number 3 in the house of her parents. This court, by order dated 28/7/2023, directed for mediation, and mediation has already been held, and the report of the mediation report has dated 5/10/2023 has been received, which indicates that mediation has failed. The Learned Counsel for the petitioner submitted that the petitioner filed a petition for restitution of conjugal rights before the Family Court,
Family Court, Noyagad, my lord.
Noyagad, by CP number 90 of 2020, which was allowed, and the opposite party number 3 has been directed by the Learned Family Court to join the company of the petitioner within 2 months, but she has not yet joined. Though the Learned Counsel for the petitioner submits that till he approaches the competent court for determining the guardianship of the opposite party number 6, the petitioner may be given the visiting rights of his son, that is opposite party number 6. In the meantime, we find that
I have not filed, my lord. I will approach.
no, he is to approach it. We are of the view that in case such a petition is filed before the competent court, the same shall be adjudicated in accordance with law, and interim order, if any, can be passed by the said court. At this stage, we are satisfied that the opposite party number 6, who is in the company of his mother, cannot be said to be wrongfully confined or illegally detained by her, and therefore we are of the view that no further order is required to be passed in this writ petition, which is accordingly disposed of. Yes.
My lord, your lordship may say that prayer, my lord, opposite party number 3 and 1, opposite party number 3 and the petitioner is at liberty to take appropriate
Yes,
steps for.
Next, and go and file the case. Yes, next item number 16.
Item 16.
Item 16, may I please?
Yeah.
Last occasion, my lordship was given direction for a conciliation.
My lord, this is also regarding custody by the wife, which is not maintainable in view of the fact that father is the natural guardian under section 6 of the Hindu Minority Guardianship Act. And in view of your lordship's judgment.
No, what happened in the mediation?
Mediation failed.
Failed. Party shall appear. So where is that report?
Report has been filed. I am having a report if your lordship.
A mediation report has seen the flag. Okay. Unsuccessful, acha.
My lord, there are several.
Husband? No, this prayer has been made in this habeas corpus by the wife.
Yes.
For the custody of her children. One is a boy and the other is a girl.
Twin.
So,
Twins.
Twin man.
Aged about 4 years.
About 5 years. About 5 years.
Or a twin child. Now, this twin is now in the company of their father. That is opposite party number 4, Sai Shankar Chaudhary, right?
Yes,
Yes.
And what is the avocation of this opposite party number 4? Kaun se kare?
Engineer.
Huh?
Engineer MBA.
Engineer.
MBA he is staying at Pune with with his parents, elder brother, sister-in-law. Joint
No,
family.
what proceeding has been initiated by the
Proceeding has been-
petitioner?
Petitioner has filed DV cases at Bhubaneswar and also 498A and other things. So far as
and
498A allegation.
Filed the Bhubaneswar, filed the Pune.
Konda?
That is OP number 4.
No. You are for the petitioner, na?
No, yes.
I am from the petitioner.
Yes.
My lord,
What
DV case
cases have been filed by the petitioner against the opposite party number 4?
Page 7 to 13, my lordship. Copy of FIR, my lordship. I have lost the FIR against this.
FIR.
So that is a 498 case.
And apart from it, DV case has been filed. And one case has been filed before the learned judge family court for restitution of conjugal right. And I have filed a petition for divorce at Pune, which has been challenged before the Honorable Supreme Court for transfer of the same to the Orissa. It is pending.
So Pune re apon file karchanti husband tarafru divorce
file karchi.
Okay. Restitution of conjugal right petition it is pending also. In which court? Family court? Bhubaneswar. Now, if the mediation has failed, then the scope is very limited in this petition. You are to every other thing that can be adjudicated by the competent court. So you are to file a petition to determine who is to be the guardian, in whose companies you will stay. In that case, the maybe the court has to decide that the best interest of the children would be served if they stay in the company of this either the father or the mother, and the other party may be given visiting rights. So that forum is completely different, that you have not approached till date. So why habeas corpus will be entertained?
Habeas corpus file, my lordship, that only cause production of 2 children. With
unless we find that she has been illegally
illegally detained.
How
They are with husband.
Husband.
They are with the father. They are with the father.
He doesn't want to talk with his wife, and he doesn't want to settle this matter, and he doesn't want to talk with the.
ଯେତେବେଳେ mediation ହେଲା ଉଭୟ ପକ୍ଷ ଆସିଲେ ନା ନାହିଁ?
ହେଲା
ପିଲାମାନେ ଆସିଥିବେ ନିଶ୍ଚୟ। ତ ଆପଣ ମାନଙ୍କ ଭିତରେ ତ ହେଇ ପାରିଲାନି।
Allegation counter allegation they are malicious.
ହେଇ ପାରିଲାନି। ବର୍ତ୍ତମାନ appropriate court କୁ ଯାଇ decide ହେବେ କରିବେ କିଏ ଛୁଆ ଆସିଥିଲେ ପୁରା mediation center କହୁଛନ୍ତି।
ସେଟା ଏଠି କଣ କରିବେ?
ଏଠି ଆମେ କଣ କରିବୁ?
They will not talk with the video conference. We will not receive the call of the video conference by the
that can be adjudicated in the appropriate proceeding, which is to be filed under the Guardians and Wards Act.
And that also the child, the minor child, will be taken with the custody of the mother as per the decisions of the Supreme Court.
ସବୁ ଠିକ ଅଛି, ସେଇ ଯୋଉ ଫୋରମ କୁ ଗଲେ ସେ ଡିସାଇଡ କରିଦବ। ଆମର ଆପଣ ଗୋଟେ ପିଟିସନ ଦେଇକିନି ଅନ୍ୟ ପ୍ରେୟାର ଗୋଟେ କରିକିନି ଅନ୍ୟ ଜିନିଷ ନେଲେ କେମିତି ହବ କି? ଦେଖନ୍ତୁ this
in the
yes
I only that if the opposite party
you have not as yet applied for that before the competent court. What prayer you are seeking for, that can be granted and some proceeding would have been conducted in that, but till date you have not filed that petition. As you have been submitted, you have initiated a DV case, you have filed a FIR, you have filed a restitution of conjugal right, but that petition should have been filed if you sincerely want that the children is to stay in your company.
If my lordship give me time, I will form some affidavit.
We are disposing of. We are not.
Affidavit, my lordship.
11. WP SCRL number 96 of 2023. The petitioner SHRI Samantray has filed this writ petition with a prayer or a direction for production of the twins of the petitioner and the opposite party number 4 before this court, and to give them in the uh, uh, in the custody of the petitioner. It appears that this court referred the matter for mediation as per order dated 16/8/2023, and in the meantime the report has been received from coordinated High Court of Orissa Mediation Center, which indicates that the mediation became unsuccessful. It has been brought to the notice of this court by the parties that the petitioner has not only filed an FIR before the inspector in charge of Mahila Police Station, Bhubaneswar, on 2/6/2023, for which Mahila PS case number 92 dated 2/6/2023 has been registered under section 498-294-506 by 34 of the Indian Penal Code, reduce section 4 of the Dowry Prohibition Act against the opposite party number 4, but also instituted DV case proceeding and proceeding for restitution of conjugal rights in the courts at Bhubaneswar, and those are sub judice. It has also been brought to of this court that the opposite party number 4 has filed a divorce case against the petitioner at Pune, where she is where he is working as engineer, na kaun pehle? Where he is working as he was working as an engineer, and the petitioner has filed a petition before the Honorable Supreme Court for transfer of that divorce case to Bhubaneswar for its trial, along with the petition for restitution of conjugal rights filed by the petitioner. In view of it is also brought to this notice when a query is made to the London Council for the petitioner as to whether for getting custody of the two children, the twins, whether any appropriate petition has been filed under the Guardianship and Wards Act before any court. The London Council submitted that it is yet to be filed. Since at this stage we don't find that the twins of the petitioner and the opposite party number 4 are under illegal confinement or wrongful detention by the opposite party number 4, we don't want to proceed further with this writ petition, which is accordingly disposed of.
My lord, with a small prayer, with a small prayer, last occasion, was directed for the personal appearance of both the parties. In the last order, both the parties appeared and talked with the husband, talk with his wife, and also the children is interested to talk with his mother. That mediation is stated in the presence of his honorable lordships, and I will give facility to my child, talk with my twins to talk with my mother, my lordship. But in the mediation center, they denied and they avoid their twin children to talk with his mother. That is the main thing. He has refused.
Don't waste time. Yes, next.
That is the
Item
main.
17.
If my lordship, I will file some affidavit with the some other documents, my lordship.
Item number 17. Yes.
17, my lord, may I pray The IH has recently joined few days back. Let it be on 11th. So, what progress?
IAC of Ku
IH
Thanaro.
Banki, my lord.
You want some further time. On 11th, you want
11th or 18th, my lord.
the Land Council for the petitioner. So also the Land Council for the state is present. Land Council for the state submitted that the inspector in charge, new inspector in charge of Banki police station has joined recently, and is some further time may be granted to him to carry forward the investigation and to apprise this court about the development made as per the এটা ଆଗରୁ କଣ ପାସ୍ ହେଇଥିଲା development made for rescue of the victim girl and also to arrest the accused person. As prayed for list this matter in the week commencing from 11th of December 2023.
Item 18.
My lord, only pair for cost production of minor debtor of the petitioner, my lord. So since she is missing 17/9.
Age of the
16, my lord.
16. As on the date of occurrence.
25/9/2007.
So the FIR it has been registered as Dhamnagar PS case number 440 dated 17/9/2023. So earlier order we have passed that
6/11.
right. State to obtain the status of the case, steps taken by the investigating officer to rescue the victim and to produce the case diary on the next date. So and so IAC.
In there, I talked with the IAC Dhamnagar, but there is some mera is going on there. Mera fera chalichi. Next week, let it come. I will bring the status.
Acha. All right. The Learning Council for the state submits that the matter may be taken up next week so that the investigating officer shall remain present to apprise this court about the development made in the meantime for the rescue of the victim girl, and he shall also produce the case diary on that day. Put up this matter. 28 तारीख रखिबा कहउछन. All right. Put up this matter on 28th November 2020. Yes.
Item 19.
May please your lordship, madam.
Yeah.
The case is totally based upon the
Yes. କିଛି part hard matter ନଥିଲା এটা fresh matter ଟା ନା ठीक ତ okay start your
May please your lordship, madam. The case is totally based upon the
302 case.
Yes, madam.
Single person.
Yes.
So come to the 302 and also 201. You have been found guilty, right?
Yes, madam.
So please come to the FIR. Let us know that what is the
Yes,
case.
madam. FIR is at
Just. Yes.
Page 18, madam. FIR lost by one Gopal Munda, madam.
PW?
PW1.
Yes.
He lost, madam.
पढ़ंतु
गत 30
माइक को एडजस्ट ये कर दियंतु.
ଗତ 30/12/2005 ତାରିଖ ଦିନ ଅପରାହ୍ନ ଥାନାକୁ ଆସି ଆପଣଙ୍କ ପାଖରେ ଏହି ମୌଖିକ ରିପୋର୍ଟ ଦେଇଅଛି ଯେ ଗତ 29/12/2005 ଦିନ ସନ୍ଧ୍ୟା 5 ଘଣ୍ଟା ସମୟରେ ମୁଁ ମୋର ବଳଦ ପଟେ ଘରକୁ ଫେରି ନଥିବାରୁ ଖୋଜୁଥିବା ସମୟରେ ସୁନାମୁଣ୍ଡାର ଜଙ୍ଗଲକୁ ଲାଗିଥିବା ବାଡ଼ିରେ ଦେଖିବାକୁ ପାଇଲି ଯେ ଜଣେ ସ୍ତ୍ରୀ ଲୋକ ମରି ପଡ଼ିଅଛି।
ସୁନାମୁଣ୍ଡା ମାନେ ଗୋଟେ ଜାଗା ନା
ସୁନାମୁଣ୍ଡା ଗୋଟେ ଲୋକ ନା ତାର ଜାଗା।
ହଁ ସୁନାମୁଣ୍ଡା ଗୋଟେ
ଲୋକ ତାର ବାଡ଼ିରେ ପଡ଼ିଥିଲା। ସେ ବାଡ଼ିଟା ହଉଛି ଜଙ୍ଗଲକୁ ଲାଗିଛି।
ସୁନାମୁଣ୍ଡା
ସୁନାମୁଣ୍ଡାର ଜଙ୍ଗଲକୁ ଲାଗିଥିବା ବାଡ଼ିରେ।
ସୁନାମୁଣ୍ଡାର ଘରକୁ ଲାଗିଥିବା ଏମିତି କଥା ଜଙ୍ଗଲକୁ ଲାଗିଥିବା
ଜଙ୍ଗଲକୁ ଲାଗିଥିବା ବାଡ଼ିରେ ମାନେ ତା ବାଡ଼ିଟା ଜଙ୍ଗଲ ଅଛି।
ଆଚ୍ଛା ହଉ ହଁ ଜଣେ ସ୍ତ୍ରୀ ଲୋକ ପଡ଼ିଅଛି ହଁ ତାପରେ
ପାଖକୁ ଯାଇ ଦେଖିଲି ଯେ ସେ ମୋର ଖୁଡ଼ି ଶଙ୍କରେଇ ମୁଣ୍ଡା।
ଶଙ୍କରେଇ ମୁଣ୍ଡା in this case is the deceased. Okay ହଁ
ମୁଣ୍ଡରେ ଆଘାତ ଲାଗି ରକ୍ତାକ୍ତ ହୋଇ ମରି ପଡ଼ିଅଛି। ତାପରେ ମୁଁ ଆସି ଗ୍ରାମର ୱାର୍ଡ ମେମ୍ବର ଦଶରା ମୁଣ୍ଡା
କେତେ
ନଟ୍ ଏକ୍ସାମିନ୍ ମାଇଲର
ଓକେ
ଓ ଅନ୍ୟମାନଙ୍କୁ ଏକଥା କହିଲି ଓ ବୁଝାବୁଝି କରିବାରେ ଜାଣିଲି ଯେ ଗତ ବୁଧବାର 28/12/5 ସନ୍ଧ୍ୟା 5ଟା ସମୟରେ ସମା ମୁଣ୍ଡା ପିତା ପାଇକର ମୁଣ୍ଡା ଯିଏକି ଆମ ଗ୍ରାମରେ ଥିବା ତାର ଭେଣେଇ ଘର କାମ ପାଇଁ ଆସିଥିଲା। ସେତିକି ବେଳେ ଶଙ୍କରେଇ ମୁଣ୍ଡା ସେଠାକୁ ଆସି ଉକ୍ତ ସମା ମୁଣ୍ଡାକୁ ମୋ ନାମରେ କାହିଁକି ଡାହାଣୀ ପାଙ୍ଗଣୀ ବୋଲି କହୁଛି କହିବାରୁ
ଶଙ୍କରେଇ ମୁଣ୍ଡା କିଏ
କହିବାରୁ ଉଭୟଙ୍କ ମଧ୍ୟରେ ଝଗଡ଼ା ହେଲା।
ମାନେ ଡିସିଜ୍ଡ ଆଉ ଆପେଲାଣ୍ଟ ଭିତରେ ଝଗଡ଼ା ହେଲା। ଓକେ
ଝଗଡ଼ା ସମୟରେ ମୋର ଖୁଡ଼ି ଲୁଗା ଟେକି ଦେଖେଇବାରୁ ସମା ମୁଣ୍ଡା ତାର ହେଣେଇ ଘର ଭିତରକୁ ଯାଇ ତା ହେଣେଇର ଗୋଟେ ବାଉଁଶ ଲାଠି ଓ ଗୋଟିଏ ଟାଙ୍ଗି ଆଣି ପିଟି ହାଣି ଜୀବନରେ ମାରି ପକାଇଲା। ଏହା ଦେଖି ପାଖରେ ଉପସ୍ଥିତ ଲୋକମାନେ ଡରରେ ପଳାଇଗଲେ। ଏହା ଜାଣିବା ପରେ ଥାନାକୁ ଆସିବା ପାଇଁ କୌଣସି ସୁବିଧା ନଥିବାରୁ ଓ ପାହାଡ଼ିଆ ରାସ୍ତା ଜୀବଜନ୍ତୁ ମାନଙ୍କର ଭୟ ଥିବାରୁ ଥାନାକୁ ଆସି ଜଣାଇ ପାରିଲି ନାହିଁ ଓ ସୁନା ମୁଣ୍ଡା ସୁତାର ମୁଣ୍ଡା ମାଟା ମୁଣ୍ଡା ଓ ଗୋରା ମୁଣ୍ଡା ମିଶି ଜଗି ରହିଲୁ। ସମା ମୁଣ୍ଡା ମୋର ଖୁଡ଼ି ଶଙ୍କରେଇ ମୁଣ୍ଡାକୁ ଡାହାଣୀ ପାଙ୍ଗିଣୀ କହି ଜୀବନ ମାରି ଦେଇଥିବାରୁ ଦାବି ରଖି ଏହି ଏତଲା ଦେଲି। ଏହାର ତଦନ୍ତ ହେଉ ମୋର ଖୁଡ଼ିକୁ ଜୀବନ ମାରିଦେଲା ଓ ମୃତଦେହକୁ ନେଇ ସୁନା ମୁଣ୍ଡାର ବାଡ଼ିରେ ଫିଙ୍ଗିଦେଲା।
So you started your submission that there is no eyewitness to the
Yes,
affair. Okay, if there is no eyewitness, then what are the circumstantial evidence which has been relied upon by the London trial court to convict you?
London trial court held the PW6
anywhere it has been summarized that these are the circumstances in the impugned judgment.
PW6 is depicted as a eyewitness.
As it appears from the FIR portion.
Son of the appellant.
And the version of PW6 also is that of an eyewitness, Your Lordship.
So, but he said that there is no eyewitness. All right, come to the PW6.
Yes, my lord.
Page 32, my lord.
I know the accused and deceased Sankari, who is my mother. Before last Makar, my mother has expired. The house of Goramunda is just near my house. Goramunda house ja bhinei ghar ku ji astila. Appellant bhinei ghar. It's just near my house. On the occurrence day at about 6-7 p.m. when it was not fully dark and persons could be recognized, the accused assaulted by axe to the head of my mother in the house of Gora and killed her. Gora is my Sangat. Gopal had called my mother. Gopal is the informant, my lord. Gopal had called my mother to the house of Goramunda, where the accused killed her. Lest the accused may killed me.
Goramunda mane ki?
Ye bhinei, appellant bhinei.
He has not been examined.
Yes, Goramunda examined.
PW2, your lordship.
PW2,
yes,
okay.
Goramunda. Lest the accused may killed me, so out of fear I fled away. While the accused was killing my mother, I had fled out of fear. Then cross, my lord. Many months prior to the occurrence, I did know the accused. The accused had no previous enmity with my mother, myself prior to the death of my mother. Our Sahi is situated in a stony area. Sometimes my mother used to take liquor. In our Munda caste, houses are of low level and one used to bend while entering into the house. My house is about 70 cubits away from the house of Goramunda. House of Goramunda is visible to my house.
There is house of only Sunamunda between my house and house of Goramunda. The accused assaulted my mother by X inside the house of Goramunda. I had gone inside the house of Goramunda when accused was assaulting my mother by X. It is not a fact that I have not gone inside the house of Goramunda. I was examined by police. It is not a fact that I have not stated before the police that Gopal called my mother to the house of Gora. It is not a fact that I have not stated before the IO that Sama assaulted by X to my mother in the house of Gora and killed her. It is not a fact not seen the incidents. It is not a fact that I am deposing false matter.
So how did you say that there is no direct evidence? As it appears from this evidence of PW6, he was present at the scene of occurrence.
Because the ମାଆ କୁ ମାରୁଛି ଗୋଟେ ପୁଅ ଦେଖୁଛି.
No,
And
no, even
yes,
that's a different
that
matter.
is different. You are coming to
Whether his evidence would be acceptable or not,
Yes,
matter
yes,
is
yes.
different. But once you say that it's a case based on circumstantial evidence, you are making a wrong
No,
statement.
no, I was submitting ki only basing of the PW6 matter,
No,
not
you
the
started
circumstances.
the argument that it's a case
By
based on circumstantial
No,
evidence.
no, I was submitting matter the
It's
base of
all
the
ideal.
PW6
So
matter. Because
now
yes,
PW6, as it appears, prosecution has adduced the evidence of PW6 to be an eyewitness to the occurrence.
yes,
And
as per the incident matter
wait.
occurrence.
His statement, which in paragraph number 4, the confrontation that has been made, that it's not a fact that I have not stated before the IO that Sama Samo means this present appellant,
Yes, ma'am.
assaulted by axe to my mother in the house of Gora and killed her.
Yes.
Whether that has been proved to the investigating officer. So not a fact, Koilana. Who is the IO in this case?
PW9 matter. Page 38.
No, page 38, but where he said that.
That particular part.
Yes,
this man's name is Guna means PW6 as a paragraph number 12. PW Guna has not stated before me that Gopala
called his mother.
Gopala called his mother to the house of Gora and Samo assaulted by axe to his mother in the house of Gora and killed her.
Not stated.
Not stated. अच्छा देखियो 161 टा करो ठीक है ये जो लोकटार PW6 ता नाम होची गुणा मुंडा এটা নয় এটা 1 ট্রায়াল কোর্ট রেকর্ড হয় তো এটা ট্রায়াল কোর্ট রেকর্ড আচ্ছা 161 ওটা তার লাস্ট আড়ু থিব বোধ ফাইল কেস ডায়েরি তো আছে
case
31 ହେଇଛି।
ହଁ ଏଠି ଅଛି ଅଛି ଗୁଣ 10 ର ହଁ କେସ୍ ଡାଏରୀ ଅଛି ଗୁଣ ମୁଣ୍ଡା ପାଇଲେ କେସ୍ 64 ହଁ ଉପରେ ନମ୍ବର ଦିଆଯାଇଛି ଯୋଉଟା ରାଉଣ୍ଡ ବୁଲା ହେଇଛି ମୋ ନାମ ଗୁଣା ମୁଣ୍ଡା ଏଇକି ସୁଆଂଶୁ ଆଜି ଆପଣଙ୍କ ପାଖରେ ବୟାନ ଦଉଛି ଯେ ଗତ 7/8 ସୁଆଂଶୁ ଦିନ ମୁଁ ମୋର ଘରେ ଥିବା ସମୟରେ ଗୋରା ମୁଣ୍ଡା ଘରକୁ ଆସିଥିବା ବୋଡଭଙ୍ଗା ଗ୍ରାମର ସମା ମୁଣ୍ଡା ମାନେ ଆପେଲାଣି ମୋର ମା ଶଙ୍କରେଇ ମୁଣ୍ଡାକୁ ପାଙ୍ଗିନୀ ଡାଆଣୀ ବୋଲି ପାଟିତୁଣ୍ଡ କରୁଥିବା ସମୟରେ ମୁଁ ଆମ ଘର ବାହାରେ ଛିଡା ହୋଇଥିଲି ସମା ମୁଣ୍ଡା ମୋର ବାହାକୁ ହାତରେ ଧରି ଗୋରା ମୁଣ୍ଡାର ଘର ଭିତରକୁ ଟାଣି ନେଇଗଲା ସମୟ ପ୍ରାୟ ସେତେବେଳକୁ 5ଟା ହବ କିଛି ସମୟ ପରେ ସମା ମୁଣ୍ଡା ଗୋରା ମୁଣ୍ଡା ଘର ଭିତରୁ ମୋର ମାକୁ କାନ୍ଧରେ ବୋହି ଆମ ଘର ପାଖକୁ ଲାଗିଥିବା ଜଙ୍ଗଲ ନିକଟବର୍ତ୍ତୀ ସୁନା ମୁଣ୍ଡାର ବାଡିରେ ଫିଙ୍ଗି ଦେଇ ଗଲା ମୁଁ ସେଠାରୁ ଦୌଡ଼ି ପଳାଇ ଗଲି ମୁଁ ପାଖକୁ ଯାଇ ଦେଖିଲି ଯେ ମୋ ମା ମୁଣ୍ଡରେ ଆଘାତ ଲାଗି ମରିଛି ମୁଁ ଭୟରେ ମତେ ଜୀବନରେ ମାରିଦେବ କହି ମୁଁ ମୋର ମାମୁଁ ଘର ମୋର ସାନ ଭାଇକୁ ନେଇ ଭୟରେ କଣ ମୟୂର ନାଚୁ ମାମୁଁ ଘରେ କେହି ନଥିବାରୁ ମୁଁ ତାଙ୍କ ଅପେକ୍ଷାରେ ରହିଲି so it's a correct that this statement has been that he has not seen that actual part about the assault part has not been said but one thing ସେଟା କହିଛି ଯୋଉ ସେ ଯୋଉ ଗୋରା ମୁଣ୍ଡା ଘର ଭିତରେ ଯଦି ଇନସିଡେଣ୍ଟ ହଉଛି ବା ସିଏ ଯାହା କହିଛି chief examination ରେ so anybody from the house of that Gora Munda who is been examined as PW2 or PW2 himself has stated anything
Nothing, my lord.
PW
या भी ताऊ कई किसी कोई ना regarding incident.
ठीक है
गोरा मुंडा PW2
wait please read that evidence of PW2
the accused is my own brother-in-law, Sola. The accused had come to our house to attend the Sudhi ceremony of my deceased daughter towards last part of December last year. I know Sankiri who has died at the time when the accused had come to my house last year. The matter was reported to police and police came and arrested the accused. I can't say if any weapons or offense are seized in my presence.
Okay, so he has not stated anything. Nobody has also stated that this man, that means the accused, dragged the deceased into the house of PW2 or thereafter carried the body of the deceased and thrown in that jungle as per the 161 statement, whatever it may be appear.
Regarding carrying of body, one person is said, my lord.
Who is that?
PW7 Ballabha Munda.
Let us come to that.
Page 34, my lord. I know accused and this is Sankari. Before last year, Makar, I found the dead body of a Sankari lying in a land near to jungle. The accused carried the dead body of a Sankari to that place. Accused was armed with a bamboo lathi. This is that bamboo lathi by MO2. I found the accused carrying the dead body of Sankari from the distance about 25 to 30 cubic cubits when it was still lighted. I can't say if Sankari was then dead or alive. I can't say which place the accused took Sankari. I had not talked with him.
ମାନେ ଖାଲି ନବା ଦେଖିଥିଲା ମାନେ ସେଟାକୁ 25 ରୁ 30 ଫୁଟ ରେ ଦେଖିଲା ଏବଂ ଆଚ୍ଛା another thing is that if the Mr. Tripathi if Mr. Mishra if the spot according to your case as per the version of PW6 is inside the house of that PW2 which of course PW2 has not stated did your investigating officer visited the house of PW and found anything like bloodstain, earth, etc. Because the occurrence took place on 28th ଲେଖା ହେଇଛି 28 ବାରରେ ହେଇଛି ଏବଂ 30 ବାରରେ report दिया ହେଇଛି ଏବଂ investigation commence ହେଇଛି ସେଇ ଦିନଠୁ। So what is the statement of the investigating officer?
I was seized, my lord.
Huh?
I was stated, my lord.
Who line?
Para 2.
Para 2.
Para 2 रे पढ़े
PW9.
PW9 तो?
Yes,
PW9, your lord.
Okay.
During investigation.
And the lathi that was seized, in that lathi, your lordship, bloodstain have been found which match the blood group of the victim.
PW9 alla IO. During investigation, I examined the complainant. I so and so visited the spot, prepared this so and so. I examined so and so. I then searched for the accused. Could not find so and so. I again visited this spot. नहीं कोड इसे रक्त भक्त कोड कहला
Para 5.
para 5 अच्छा
At 1:45 p.m. I seized the bloodstain art and sample art from the spot.
स्पॉट माने कोड उसे मेन कोड जी एग्जिबिट 9 टा देखियो पड़ो हां 9 टा दी बाहर कले एग्जिबिट
से कुछ घर को जाई से जगह जाई
स्पॉट से कोड को मेन कोड एग्जिबिट 9 এটা कितना बजे रहेगी 8
सर सेटा पारा 10 ले कोइछ
रो
क्रॉस रे कोइछ
एग्जिबिट এটা कितना बजे
9
Exhibit 9 is the seizure list.
हाँ सीजर लिस्ट हाँ किछि रक्त भिजा माटी किछि नमूना माटी उपरोक्त केस रो तदंत करुथिबा समय घटना स्थल रु मिली गला घटना स्थल माने कोठी स्पॉट टा लिखितो प्लेस ऊपर
Spot house.
as per column number 13 एटा मिलिला address of the place अच्छा column number 4 address of the place where it was done that is Sukku Tola कौन लिखा है ये सुक्खू तोड़ा जोगिन साई PS नायकपुर डिस्ट्रिक्ट केउंझर description of the place सुक्खू तोड़ा स्वांसो PS अच्छा हाँ कौन कहले कोउथरे को पैराग्राफ रे क्लैरिफाई करजी
10 paragraph 10 ले
पैराग्राफ 10 हाँ कौन जी
I made the inquest of the dead body of the Sankari on the land of Sunamunda. I seized sample earth and blood stained earth from the house of Goramunda. I have not seized any sample earth or blood stained earth from the land of Sunamunda where the dead body was lying.
So ए जो ब्लडस्टेन आर्ट सीज ହେଇଛି ता माने आपण चीफ रे तो नथिला आपण तो क्लैरिफाई करछंती क्रॉस एग्जामिनेशन रे
नहीं
चीफ रे नथिला के खाली कहितला spot may be that where the dead body was lying and in fact in that exhibit 9 it has not been mentioned that the spot was or the place of seizure was the house of
Goramunda.
PW2 it is simply written se ganda nata lekha hai gote kon sukku dola kon gote sahi gote lekha hai जोटा कि होची PW2 रो गां तेणु ये प्रश्न किछि पचारिवार जस्टिफिकेशन ही नथिला तो
ये पुलुमुंडा ना पालामुंडा की एग्जामिन है
पालामुंडा होची गोरामुंडा रा स्त्री
से एग्जामिन है नी
है छै आज्ञा
रिट्रैक्ट करिछि तार स्टेटमेंट 164
Yes, sir. She's a hostile eyewitness.
ताकू कहले पुलिस मते कहथले कथा कहया
रिट्रैक्ट
PW4 माइनर in the judgment it is only basing of the PW6 others are not believed matter
PW6 has been believed to be an eyewitness by the Run and Trial
yes. In the spot map
but again what he has seen is the assault by means of an axe right
but bamboo recovered
but the person who has seen him leaving with that or
Bamboo.
carrying the dead body, he has stated that one bamboo lathi was seen in the hands of the appellant.
PW7 said, my
Bamboo
So,
lathi has been seized.
bamboo lathi has been seized or axe?
No,
Both-
bamboo lathi and axe both have been
Both
seized.
have been seized.
And
Where this axe was seized and where the bamboo lathi was seized. କାରଣ ଯଦି ତାମାନେ ଆକ୍ଟ ତାକୁ ଘରେ ଛାଡିକି ଆସିଥିବ ମାନେ
regarding seizure, my lord,
Yeah.
very much contradiction. I'm reading, my lord. One Sunna Munda, PW3, my lord.
No, na ki IO evidence ko asan.
IO PW9.
IO PW9 come to paragraph number 4.
Yes.
At 1:30, I seized one bamboo lathi and one axe from the house of Samramunda.
Yes, Samramunda, who is Samramunda unknown, my lord. Not
Who is
been examined.
It's all right from
Yes.
on the production of the accused and
Accused.
prepare the seizure list exhibit 8.
Yes.
Exhibit 8 ଟା ଦେଇ ଦେଖିଦବା.
ଗୋଟେ ବାଉଁଶ ଲାଠି ଯାହାର ଲମ୍ବ 4 ଫୁଟ 2 ଇଞ୍ଚ ରକ୍ତ ଲାଗିଥାଏ.
ଗୋଟେ ଠାଙ୍ଗିଆ ଏଟା ଲେଖା ହେଇଛି ଉପରେ circumstance of seizure. ମୁଦାଲା ପାଖରୁ ଗୋଟେ ବାଉଁଶ ଲାଠି ଯାହାର ଶୁଆଂଶ
ଟାଙ୍ଗିଆ
ଯାହାର ଟାଙ୍ଗିଆ ବେଣ୍ଟ ସାକ୍ଷୀ ମାନଙ୍କର ଉପସ୍ଥିତିରେ ଜବତ କରାଗଲା ଆଉ ଜବତ ତାରିଖରେ ଏଟା ଦେଇଛି person from whom it was recovered paragraph number column number 5 ରେ ସେଟା ଦେଇଛି ସମାମୁଣ୍ଡା ତାମାନେ ପିଟିସନର ଟୁ ସେଟା ଜବତ ହେଇଛି ଦିଟା ଆଗ it is not ଏବଂ ସେଇଆ ହିଁ ଲେଖା ହେଇଛି circumstance of seizure ଯେ ତଦନ୍ତ କରୁଥିବା ସମୟରେ ମୁଦାଲା ସମାମୁଣ୍ଡା ପାଖରୁ ଗୋଟିଏ ବାଉଁଶ ଲାଠି ଯାହାର ଲମ୍ବ ଶୁଆଂଶ ଟାଙ୍ଗିଆ ବେଣ୍ଟ ଯାହାର ଏତିକି ଲମ୍ବ ସାକ୍ଷୀ ମାନଙ୍କର ଉପସ୍ଥିତିରେ ଜବତ କରାଯାଇ ତାଲିକା ପ୍ରସ୍ତୁତ କରାଗଲା. So
କିନ୍ତୁ ସାକ୍ଷୀ ମାନେ ତ ଅନ୍ୟ କଥା କହୁଛନ୍ତି.
ସାକ୍ଷୀ ମାନେ
ଯାହାର ପ୍ରେଜେନ୍ସ ରେ ସିଜ୍ ହେଲା they are saying different thing, my lord.
ଇଏ ସମାରୁ
ନାଇଁ other ସୁନା ମୁଣ୍ଡା and କୃଷ୍ଣ ମୁଣ୍ଡା.
ନା ସମାରୁ ପରା
ସମରା ମୁଣ୍ଡା ତ not examined.
ସମାରୁ ଆଉ କୃଷ୍ଣ
Not examined.
Krishna has been examined.
Yes. Sunna Munda also examined.
It appears from the evidence of PW6,
Yes.
whose evidence has been believed by the Learned Trial Court, that only one axe has been used for assaulting the deceased.
Yes.
As it appears, no lathi was used.
Yes.
ଯଦି eyewitness ର statement ଟାକୁ believe କରାଯିବ ସେ axe କୁ ଆପଣ ଧରିକିନି ଯାଉଥିଲେ ବୋଲି PW7 କହିନି.
Right.
PW7 କହୁଛି ଗୋଟେ ବାମ୍ବୋ ଲାଠି ଯୋଉଟା କି ୱେପନ ଅଫ ଅଫେନ୍ସ ନୁହେଁ ହେଲା ଯୋଉଟା କି ଆପଣଙ୍କ ପୋଜିସନ ରୁ ଜବତ ହେଇଛି କିନ୍ତୁ ଯୋଉ ସି ରିପୋର୍ଟ ଅନୁଯାୟୀ what Mr. Mishra pointed out that lathi was containing blood stain and that was also human ସେଟା କେତେ number page
Lordship page 43
हाँ ब्लड रे अछि ह्यूमन ब्लड ग्रुप बी आक्स रे किछि ब्लड नहीं अच्छा and the doctor has stated that it is possible by the lathi.
Yes.
Who is that doctor?
PW8, your lordship. Paragraph 4 he has stated.
Engine number 1, 2, 3 might have been caused by weapon having cutting edge, and engine number 4 have been caused by blunt object. Page 35, paragraph 2, my lord.
Yes, in the opinion, in the column number, paragraph number 2, the doctor has also stated that injury number 1, 2, 3 might have been caused by a cutting edge. That means you farsar dwara madhya hei paribo. Injury number 4 have been caused by blunt object. So all the three blows, as we find, it is on the vital part of the body. First one is the left mandibular region. Second is on the left ear pinna. Third blow is on the left side neck. That is at page 35. Subsequently, he received a query that with an axe and bamboo lathi, and he opined that bloodstain was there in the bamboo lathi. Opined that the injuries, as per my PM report, are possible by these bamboo lathi and axe. The generally koila.
He has given a very specific finding at paragraph 4, Your Lordship. The PW8, the doctor.
Since there is no muscle between the
skull and skin,
assault by blunt object on the skull may look like an incised wound. The depressed bone fracture on the deceased can be possible by
bamboo
lathi.
So from my understanding, what he's submitting is that could have been possible just by the lathi itself also.
No X.
Since there is no muscle between this one, so by blunt object may look like inside on the depressed bone fracture. Depressed bone fracture মানে সেটা বোধে কো ইনজুরি কো ইয়ে করছি
mandible ଯୋଉଟା ହେଇଛି
internal injury on dissection there was depressed fracture as a left temporal region ମୁଣ୍ଡଟାରେ ଯୋଉଟା ମାଡଟା ହେଇଛି ମାନେ that is maybe that either number 1 or 2 one ଟା ହଉଛି it was a decomposition first injury ଟା କହୁଛି incised wound ତା ଭିତରେ ରହିଯାଇଛି ପ୍ରଥମ paragraph ରେ present over left temporal region half inch and second is that incised wound present over the left side face. Third is on the left ear.
Right.
So three injuries are on the head portion and the top injury, that means injury number one, that has caused also the internal injury, that is a depressed fracture of the
temporal
and brain materials were soft, stained with blood corresponding to the fracture of the temporal region. So the cause of death was due to head injury within 5 days. So first of all, the submission which you made at the first instance that there is no eyewitness is not correct. So the second one is that it appears that PW6 is an eyewitness and his evidence has been accepted by the trial court. And PW6 has stated that the weapon of offense was an axe. And he has seen the appellant assaulting on the head of the deceased, who is none else than the mother. And the PM doctor, that is PW8, has also stated that the weapon, that is axe, can cause some injuries, that particularly 1, 2, 3, and the lathi can cause the lacerated injury, that is injury number 4. And the version of PW6 gets corroboration from evidence of PW7 because he has seen the appellant carrying the dead body of the deceased, and at that time he was armed with a bamboo lathi. So, and that apart, the blood stain which was found on that bamboo lathi is of human origin and of group B. So when if this evidence is accepted, coupled with the fact that you assaulted a lady who was unarmed repeatedly dealt 3 blows on the head portion, one on the right on the front, then the other is on the mandibular, ଆଉ ଗୋଟେ left ପିନା ପାଖରେ ତିନିଟା injury ଆପଣ ଗୋଟେ ଟାଙ୍ଗିଆରେ ମାରିଛନ୍ତି. Apart from that, ଏଇଆ ଯଦି evidence ଟା accept ହୁଏ, then your intention is also very much clear. କାରଣ ବାକି ତାକୁ ଆପଣ ଘର ଭିତରକୁ ଡ୍ରାଗ୍ କରିକି ନେଇକିନି ଯାଇଛନ୍ତି ବୋଲି ଅବଶ୍ୟ 161 ରେ ଅଛି, but ଏଠି ସେ ବିଷୟରେ ନାହିଁ.
He is saying he has seen
ସେଟା
inside.
direct କରିଦେଇଛି ସେ
ସେଟା ଡାଇରେକ୍ଟ କରିଦେଇଛି, କାରଣ ସେ କହିଛି ଯେ ବୋଧେ assaulted so-and-so. Acha, the accused had no previous enmity, so-and-so. My house was so-and-so. There was a house of.
ଏଇଟାକୁ rely କରି spot map ବି totally contradiction ମାଇଲା.
I had gone to the house of Mulamunda when my accused assaulted my mother. But if this part of the statement of that PW6 is left out,
yes.
Let us say because he has not stated before the IO, actual assault part,
yes.
then ଆମେ ଯଦି ସେଇଟାକୁ skip ବା ଛାଡ଼ି ଦବୁ, ବାକି ରହିଲା PW6 ର evidence ରେ ଆଉ କଣ ରହିଲା?
That he has seen his
Seen
mother
only
being
inside
dragged to
the
the house and again brought out.
Dragged କୋଉଠି କହୁଛି?
ନା drag କଥା 161 ରେ କହିଛି, but in this deposition କହିଛି ମୁଁ ଘର ଭିତରେ ଦେଖିଲି ବୋଲି.
Please wait. PW6 ର evidence ରେ dragging part ନାହିଁ.
Here he gave a direct
हाँ, तो से dragging absent अछि, खाली least the accused may fled away, out of fear I fled away. अच्छा, accused ଯେତେବେଳେ present ଥିଲା ସେତିକି ବେଳେ PW6 ମଧ୍ୟ ପଳେଇଛି. Then the only evidence remains is that of PW7, is that he had seen the carrying the dead body and so and so. And so Mr. Mishra, PW6 ର evidence jaha ati court re kohuchi regarding assault part, that is not there in the before the police. It is stated for the first time. So sei part ta ku jodi ame exclude kari debu, baki ta evidence re rahila kon, taku believe kariba ku je he was an eyewitness to the occurrence. In fact ଆମେ 161 ଦେଖି ସାରିଲୁଣି, ସେଇ ଫ୍ୟାକ୍ଟ ଟା ମଧ୍ୟ କହିନି, ଯୋଉ ସେ ଯୋଉ ଦେଖିବା କହୁଛି ନା ଆକ୍ସ ରେ ଯୋଉ ରିପିଟେଡ ବ୍ଲୋ ଦେଲା. ହଁ, ତେଣୁ ଏଇ ପାର୍ଟ କୁ ଯଦି ଛାଡିଦବୁ ଯେ ସେଟା ଦେଖିନି, ତାହେଲେ ବାକି ଯାହା ରହୁଛି ଦି ଏଭିଡେନ୍ସ ଅଫ PW7, କାରଣ ଆପଣଙ୍କର ଯଦିଓ PW2 ଘରେ ହେଇଛି, PW2 is totally silent. ତା ଘରେ assault ହେଇଛି, ତା ଘରେ ବାକି ଆପଣଙ୍କର ଆସିବ ଯେ maximum bloodstain earth sample earth ଟା ନେଆ ହେଲା PW2 ରୁ ଇଏ ହେଲା, ଆଉ weapon recovery ହେଲା at the instance of the appellant number 2, ଆଉ number 3 ହଉଛି ଯୋଉ carrying of the dead body by as stated by PW7. ଏତିକି ଆସିବ.
Lordship, my submission is that PW6 version, even if we disbelieve the part that he has seen it directly, a conjoint reading of this along with the statement made before the IO, it can be inferred that he was there, even though not inside the house, but at least outside the house. He may not have witnessed the murder itself, but he has witnessed other facts that.
ଆଉ କଣ କହୁନାହାନ୍ତି PW6 ର evidence, ଆଉ ସେ କଣ କହିଲା ଯୋଉ ପାର୍ଟଟାକୁ ଆମେ believe କରିବା? ଆପଣ ସେଇଟାକୁ ଯଦି ଛାଡି ଦଉଛନ୍ତି, ସେ ତ ଡାଇରେକ୍ଟ ଏଠି କହିଲାନି ନା. ଯଦି କହିଥାନ୍ତା ମୁଁ ଦେଖିଲି ସିଏ ତାକୁ ଭିତରକୁ ନେଇଗଲା, ଡ୍ରାଗିଂ କଲା ବୋଲି, ଯଦି ସେଇ ଯୋଉଟା 161 କହିନି, ଯଦି ମନେ କରନ୍ତୁ ସେଇଟା କହିଥାନ୍ତା ଯେ ଡ୍ରାଗିଂ କଲା, ସେଇଟା ଗୋଟେ ରହିଥାନ୍ତା. ଏ ବର୍ତ୍ତମାନ ଡ୍ରାଗିଂ କଥା ନାହିଁ, ଟୋଟାଲ ତାର 161 ଏଇ ଯୋଉ ଆମର ଏଭିଡେନ୍ସ ରେ ନାହିଁ, ଖାଲି ଅଛି ଡାଇରେକ୍ଟ ଆସଲ୍ଟ, ଯୋଉଟା କି 161 ହିଁ ନାହିଁ ହେଲା. ତାପରେ ସେ କହୁଛି ପଳେଇଲା ସେ ଜାଗାରୁ, ତାମାନେ ଆକ୍ୟୁଜ ସେ ଜାଗାରୁ ଯିବା ପର୍ଯ୍ୟନ୍ତ ସେ ସେଠି ଉପସ୍ଥିତ ନାହିଁ। ତେଣୁ ବାକି ଏତିକି ଯଦି ଅଛି ତେଣୁ ଓନ୍ଲି ଏଭିଡେନ୍ସ ରହିଲା PW7 ର। PW7 ର ଯଦି ଏଭିଡେନ୍ସ ଆକ୍ସେପ୍ଟ କରାଯିବ, ଲେଟ୍ ଅସ୍ ସେ ଦ୍ୟାଟ୍ ତାହେଲେ ଯେ ବଡିଟାକୁ ସେ କ୍ୟାରି କରିକି ନେଇକିନି ଗୋଟେ ଜାଗାରେ ପକେଇଦେଲା, ଗୋଟେ ଜାଗା ଏଟା ପଡିଥିଲା ସେ ଯୋଉ କୋଉ ଜଙ୍ଗଲ ଭିତରେ ନା
Sunamunda
କଣ।
side.
So whether it would be 302 or 201 only.
Lordship, again, it was the duty of the accused to answer these questions directly, Your Lordship.
ମାନେ ଆପଣ ଆଗେ 302 ର ଚାର୍ଜ ଟାକୁ ପ୍ରମାଣ କରନ୍ତୁ। 302 ର ଚାର୍ଜ ଟା ଆପଣ ତ ବେସ୍ ହେଲା ନା PW6 ର ଏଭିଡେନ୍ସ। ଏଇ ଏଭିଡେନ୍ସ ଟାକୁ ଯୋଉଟା କି ଏ ଘଟଣା ହେଲା ଆପଣଙ୍କର କେବେ ଡେଟ୍ ଅଫ୍ ଅକରେନ୍ସ କେବେ 28/5 ରେ ଘଟଣା ହେଲା ଆପଣଙ୍କର 161 ରେକର୍ଡ ହେଲା 31/5 ରେ, and you are deposing in court in 2006 22 August 2006. ତେଣୁ ମାନେ ପାଖାପାଖି ଆପଣ 8 ମାସ ପରେ ଟ୍ରାଏଲ ଷ୍ଟେଜ ରେ ଏଇ ଯୋଉ ଆଇ ୱିଟନେସ୍ ଆପଣ ଗୋଟେ ଘଟଣା ଦେଖିଥିଲେ ବୋଲି ଯୋଉ ଆସିଲା, ଏଇଟା ଏ ବିଷୟରେ ଫାର୍ଷ୍ଟ ଟାଇମ କହୁଛନ୍ତି। ତେଣୁ how this court will accept that version which has been given for the first time in court as an eyewitness to the occurrence in a murder case?
The finding of the trial court is that the investigation of the IO was perfunctory. That's why he has taken.
ସେ ତ ଯେତିକି କହିଥିଲା 161 ରେ ସେତିକ ତ ଆପଣ ଆଣିଥିଲେ ଓଲଟି ବେନିଫିଟ ହେଇଥାନ୍ତେ।
Yes.
ଏ ଯୋଉ ଡ୍ରାଗନ ଟା କଲା ଆପଣ ତ ପୁରା ନେଇଆଇଲେ ତାକୁ ଡାଇରେକ୍ଟ ଆସେଲାଣ୍ଟ ହିସାବରେ ନେଇଆଇଲେ, ଯୋଉଟା କି ନାହିଁ, ଯୋଉଟା ଅଛି ତାକୁ ଆଣିଲେନି। ଏଇଟା ହଉଛି ପବ୍ଲିକ ପ୍ରସିକ୍ୟୁଟର କାମ। ଯୋଉ ଜିନିଷଟା ନାହିଁ ତାକୁ ଆଣିଲେ, ଯୋଉ ଜିନିଷଟା ଅଛି ତାର ଭାବିବା କଥା ଯେ ସେତିକି କହିଥିଲେ ତାର ଇଫେକ୍ଟ ଟା କଣ ହେଇଥାନ୍ତା।
No, he thought that he has given a better.
maybe ଯେ ତାକୁ ସିଏ ଯୋଉଟା ଆଇ ୱିଟନେସ୍ କହିନଥିଲା ତାକୁ ନେଇଆଇଲେ ଆଇ ୱିଟନେସ୍ ହିସାବରେ। ଯୋଉ ପାର୍ଟ ରେ କହିଥିଲେ ରେଲେଭାନ୍ସ ହେଇଥାନ୍ତା, ଆଟଲିଷ୍ଟ ଟ୍ରାକ୍ କରି ନେଲା ଗୋଟେ ପାର୍ଟ ଥାନ୍ତା। ଆର ଲୋକଟା ଦେଖୁଛି ଡେଡ ବଡି କି ନେଇକିନି ଗଲା, ସୋ ତା ଛଡା ବ୍ଲଡ ମିଳିଲା, ଏଇ ଯୋଉ ଜିନିଷ ଗୁଡାକ। ତ ବର୍ତ୍ତମାନ କିଛି ନାହିଁ, ସେ ଘର ଭିତରେ ଖାଲି ଇଏ PW7 ର ଯଦି ଭର୍ସନ ଆସିବ ତାହେଲେ the accused carried the dead body of Shankari to that place I found, ଆଉ ଥରେ ପଳେଇ ଆସନ୍ତୁ ସେ ଜାଗା ଇଏରେ, ଏବଂ ସିଏ କହୁନି again come to the PW7 evidence. What he has stated, before last year I found the dead body of Shankari lying in a land near the jungle. The accused carried the dead body of Shankari to that place. Accused କୋଉଠୁ ନେଇକିନି ଗଲା ସେ evidence ନାହିଁ। The most material part of the evidence of PW7 ଯଦି ଥାନ୍ତା ଯେ PW2 ର ଘରୁ ସିଏ ଦେଖିଲା ଯେ ଡେଡ ବଡି କୁ ଇଏ ନେଇକିନି ଯାଉଛି, that would have given some kind of connection, link. ତେଣୁ ବର୍ତ୍ତମାନ ଗୋଟେ evidence ଖାଲି ଆସୁଛି ଯେ ସିଏ ଗୋଟେ ଦେଖିଲା ଜଣେ ଡେଡ ବଡି, so how it will be said that he is the author of the crime, or 302 ଆମେ କେମିତି ଆଣିବୁ କୋଉ base ରେ?
Because my humble submission is to reconsider the witness of the version of PW6, Your Lordship.
No, his veracity is in question right now.
Yes, Your Lordship, it is. But my humble submission is that, Lords, we have to believe certain aspects of the
କଣଟା aspect ଗୋଟେ witness ଯିଏ କି ତାର statement ରେ କହିନଥିବ ମୁଁ ହଉଛି ଆଇ ୱିଟନେସ୍, for the first time after so many months, if he comes to the court and depose as an eyewitness, can the court believe or accept the version? That is the question.
My humble submission is not with regard to the version that he is an ocular witness.
Then eyewitness ନୁହେଁ ଆପଣ ବି କହୁଛନ୍ତି, ତାହେଲେ ଆଉ କଣଟା ରହିଲା କହୁନାହାନ୍ତି, ତାର ଆଉ କଣ ରହିଲା?
He has stated, Lordship, one sentence which can be used is that Gopal had called my mother to the house of Goramunda.
କିଏ?
Gopal. To the house of Goramunda, which is
କାହା evidence କହୁଛନ୍ତି?
PW6, Your Lordship.
କୋଉଟା ପଢୁଛନ୍ତି?
PW6
first paragraph, the fourth line from the bottom, Your Lordship. PW
acha, this is Shankari. Before last year my mother, The house of Goramada is just near me. On
Not
the
that, not that
occurrence
part.
day,
Sorry, first paragraph. First paragraph, last 4 lines. Gopal had called my mother to the house of Goramunda.
କୋଉଟା ଟିକେ ପଢୁଛନ୍ତି ମତେ ଟିକେ କୁହନ୍ତୁ।
1 number paragraph ର
ମାନେ କାହା ଏଭିଡେନ୍ସ?
ସେ PW6 ର କ୍ରସ୍ ଏକ୍ସାମିନେସନ ଉପରଟା ସଂଗାତ ଯୋଉ ଲେଖା
ଆଚ୍ଛା
ହେଇଛି।
ଗୋରା ଆଚ୍ଛା ଓ ଏଇଟି particular line. Gora had is my Sangata and Gopala. Gopal had called my mother to the house of Gora, where the accused killed her.
ଗୋପାଳ କିଛି କହୁନି, ଗୋପାଳ 1
ନା ଗୋପାଳ କହୁଛି ନା ଗୋରା କହୁଛି। ଆପଣ ଏଭିଡେନ୍ସ ଯେ ଡିସିଜ୍ଡ କୁ ଇଏ ଡାକିକିନି ଆଣିଥିଲା ତା ଘରକୁ। ଆପଣଙ୍କର ଏଭିଡେନ୍ସ ହଉଛି କଣ ଯେ ଗୋପାଳ ଡାକିକିନି ଆଣିଲା, PW1 ଡାକିକିନି ଆଣିଲା ଡିସିଜ୍ଡ କୁ କାହା ଘରକୁ ନା PW2 ଘରକୁ। ତ ଏଭିଡେନ୍ସ କରବୋରେସନ କେମିତି ଆସିଥାନ୍ତା ଯଦି PW1 କହିଥାନ୍ତା ଯେ ହଁ ମାନେ ମୁଁ ତାକୁ ଯାଇକିନି ଡାକିକିନି ଆଣିଲି, ହେଲା ଡିସିଜ୍ଡ କୁ ଡାକିକିନି ଆଣିଥିଲି ଗୋରା ଘରକୁ। ତ ଆପଣଙ୍କର ଏଭିଡେନ୍ସ ଅଛି କି PW1 କହୁଛି?
No, that is not there.
PW2 କହୁଛି କି ଡିସିଜ୍ ଆସିଥିଲା ଆଟଲିଷ୍ଟ ତା ଘରକୁ। ତାହେଲେ ହାଉ ଡୁ ୟୁ say that in what way the evidence of ଆଉ କଣ ରହିଲା ତା evidence?
No, my submission is the only grain of truth that I am trying to elicit from here is that, Lordship, he was there at the spot, even though not inside the house. But the only common factor that comes from the 161 statement and the evidence is that he was present at the spot, Your Lordship.
କିଏ କହିଲା ସେଇଟା? କିଏ କହୁଛି?
That is my that is the inference I am trying
you
to portray
have
to Your
that
Lordship.
you intend to get the inference out of it.
Yes, Your Lordship. To add that as a chain in as a link in the chain of circumstance, Your Lordship. Even though we reject the complete ocular version of the witness.
ଆପଣଙ୍କର 1 number ସାକ୍ଷୀ ସାଇଲେଣ୍ଟ, ପ୍ରେଜେନ୍ସ ଅଫ ଆପେଲାଣ୍ଟ ଇନ୍ ଦି ହାଉସ ଅଫ PW2, ଯାହା ଘରେ ଘଟଣା ହେଇଛି PW2 ଇଜ ସାଇଲେଣ୍ଟ about the presence of PW6 ଆପଣଙ୍କର ଆଇ ୱିଟନେସ୍ ହିସାବରେ ପୋଜ କଲା which is not there in the, so how that which you ଆପଣ କହୁଛନ୍ତି ଯେ କେବଳ ଏତିକି ପାର୍ଟ ସେଟା କେମିତି ଇନଫର କରାଯିବ, କୋଉ ଏଭିଡେନ୍ସ ରୁ ଆମେ ଇନଫର କରିବୁ, କିଏ କହିଛି? ଅନ୍ୟମାନେ ହଁ ଆଇ ୱିଟନେସ୍ ତାକୁ ଆପଣ କହୁଛନ୍ତି ଆଇ ୱିଟନେସ୍ ଟା କହିନି ତାକୁ ସେ ପାର୍ଟ ଟାକୁ କାଟି ଦିଆଯାଉ, ବାକି ଯୋଉ ପ୍ରେଜେନ୍ସ ଥିଲା ବୋଲି ଯୋଉ ଘର ଯାହା ଘରେ ହୋଇଛି ସିଏ କହୁନି, ଯିଏ ଡାକିକିନି ଆଣିଥିଲା ସିଏ ବି କହୁନି, ତାହେଲେ ଆଉ କୋଉଠି ରହିଲା? ଆପଣଙ୍କର ଗୋଟେ ଏଭିଡେନ୍ସ ଆସୁଛି ଯୋଉଡାକ ଗୋଟେ ହେଲା ଗୋଟେ ବ୍ଲଡ ଷ୍ଟେନ୍ ଆର୍ଥ PW2 ର ଘରୁ ମିଳିଲା, ଇଏ ଗୋଟେ। ନେକ୍ସଟ ସର୍କମଷ୍ଟାନ୍ସ ହଉଛି ଯେ ତାର ଡେଡ ବଡି ଟାକୁ PW7 ଦେଖିଲା, ସେ ନେଇକି କୋଉଠୁ ନେଲା କହୁନି, ଖାଲି ଦେଖୁଛି ଡେଡ ବଡି ଟାକୁ କ୍ୟାରି କରି ନେଇକି ଯାଉଛି। ଏବଂ ସେତିକି ତ କହୁଛି, ଆଉ PW ତାକୁ ନେଇକି ସେ ଘଟଣା ଜାଗାରେ ପକେଇଲା ମଧ୍ୟ, ଯୋଉ ଜାଗାରୁ ମିଳିଲା ସେ କଥା ମଧ୍ୟ କହୁନି, ବଟ୍ ଇଏ କହୁଛି। ଏବଂ ହି ୱାଜ ହୋଲ୍ଡିଂ ଏ ବାମ୍ବୁ ଲାଠି at that point of time, which was of course stained with human blood.
Which finds corroboration
from the C report. ଏତିକିରୁ ଆପଣ ଏତିକି circumstance ଆସିଲା, ଏତିକି circumstance can we say again go to that principle that chain of is so complete, जो लिंक थिला यदि पब्लिक प्रोसिक्यूटर से को स्टिक करथांदा तो बहुत किछि आउ लिंक आस परथांदा, जो ड्रैगिंग एवं PW7 रो यदि एविडेंस आस्थाना मता घर भितरु मु देखि ताकु लेगी जाउतला। These are the things which could have been, but unfortunately what was not there that has been brought out, what was there and relevant that has been omitted. बाकी डेड बॉडी टाकू नेइकिनी क्यारी करले तो मैक्सिमम हेले 201 आसीबो, हाउ कैन यू से दैट?
Yes, if PW6 version is not believed, at least to the effect that he was at the spot, then these three circumstances will not form a complete chain.
That is the main.
I admit that, but
and in order to place PW6 to be at the scene of occurrence. That is a complete omission in the 161.
PW1 ଆଉ
କହିଦେଇଥାନ୍ତି ସେ ଥିଲା
ସିଏ ଥିଲା ସିଏ ବି କହୁନାହାନ୍ତି ତାଙ୍କର ଏଭିଡେନ୍ସ ବି ସାଇଡ୍ PW1 ଆଉ 2 ର ଏଭିଡେନ୍ସ ରେ ଯଦି ଆର ଆଟଲିଷ୍ଟ ପ୍ରେଜେନ୍ସ ଟା ବି ଆଣିଥାନ୍ତେ କାହାର PW6 ର ପ୍ରେଜେନ୍ସ.
So as you rightly submitted, only an inference can be drawn, but that cannot be taken as a part of evidence. Only it could be an inference. We need to go a complete a case beyond reasonable doubt, even the presence itself. Had the presence been there, then other aspects could have been taken.
All right. Take down JCRLA number 95 of 2006. The appellant Sama Munda faced trial.
A bill ଅଛି
Bail ଅଛି.
Sir, ସେ report ଗୋଟେ ମଗା ହେଇଥିଲା
ସେଟା ତ ଅଛି ତା ଘରେ ଅଛି ବୋଲିକି ତା ମାନେ ବେଲ୍ ଅଛି.
Yes, bail was allowed on 8/2/2012.
Acha.
12.
Faced trial in the court of କେତେ ଦିନ ରହିଛି ଏଠି? Final form in the court of London ad hoc additional session judge FTC2 Keunjhar in ST case number 33/68 of 2006 for offences punishable under section 302 and 201 of the Indian Penal Code on the accusation that on 28/12/2005 at about 5 p.m. he committed murder of one Sankari Munda year after the deceased, and having knowledge or reason to believe that such offense has been committed, he caused the evidence connected with the said offense to disappear by throwing the dead body of the deceased in the body of Sanna Munda bracket Sunna Munda bracket PW3 with intention to screen himself from legal punishment. The London Trial Court, by judgment and order dated 2/9/2006, found the appellant guilty of both the charges and sentenced him to undergo imprisonment for life and to pay fine of ₹5,000 in default to undergo RI for 1 year under section 302 of the Indian Penal Code, and to undergo RI for 3 years and to pay fine of ₹1,000 in default to undergo RI for 3 months under section 201 of the Indian Penal Code, and both the substantive sentences were directed to run concurrently. The prosecution case, as per the oral report submitted by Gopal Munda bracket PW1 before the officer in charge of Nayakot Police Station on 30/12/2005 is that on 29/12/2005 in the afternoon at about 5 o'clock, while he was searching for his bullocks, he noticed the dead body of a lady was lying in the backyard of one PW of Suna Munda, bracket PW3. And when he reached closer to the dead body, he could find that it was the body of the deceased, and there was bleeding injury on her person. PW1 immediately intimated the same to the ward member and others, and subsequently he came to know that on 28/12/2005 at about 5 p.m. the appellant, who had come to the house of his brother-in-law for getting some work, was confronted by the deceased as to why she was told as to be practicing witchcraft. And over this issue, there was quarrel between the appellant and the deceased. And during such quarrel, the deceased was assaulted by means of a lathi, so also by means of a tangia inside the house of the brother-in-law of the appellant. And after committing the murder, the dead body was thrown in the backyard of the house of PW3. Since there was no proper communication between the place of occurrence and the police station, and it was a hilly area, and there was fear of animals, the immediately matter could not be reported in the police station, and for which the dead body was guarded and stopped. On the basis of the oral report given by PW1, the officer in charge of Nagpur police station reduced the same into writing, and on the basis of such report, Naya Court Police Station PS case number 31 dated 30/12/2005 was registered under section 302 of the Indian Penal Code against the appellant, and PW9 Trilochan Naik in the SI of Barpal outpost under Naya Court Police Station took up investigation of the case. Stop. During course of investigation, PW9 examined the informant, visited the spot, prepared the spot map, Exhibit 4, examine the other witnesses and try to uh, find out the whereabouts of the appellant, but was unsuccessful on that day. On 31/12/2005, PW9 again visited the spot, examined some more witnesses, held inquest over the dead body as per inquest report Exhibit 5, and sent the dead body for post-mortem examination. The appellant was arrested on that day, and from the house of one Samara Munda, who is the brother-in-law of the appellant, one bamboo lathi and one axe was seized on production by the appellant as per seizure list Exhibit 8. On that day, at about 1:45 p.m., the bloodstain earth and sample earth were seized from the spot as per seizure list Exhibit 9. The white color full shirt of the appellant was also seized as per seizure list Exhibit 10. The appellant was sent to CSC Borpar for collection of his blood sample and nail clippings through constable. And Bondabahal.
বন্ধবাহাল না
বনসপাল
সেটা ভুল লিখে দিচ্ছে
আচ্ছা
এটা বন্ধবাহাল ঝাঁসুড়া এটা পরে
नहीं नहीं क्या केउंझर
তাহলে বন্ধবাহাল
Bonspar. Acha. The appellant was forwarded to court. The wearing apparels of the deceased were seized on the production by the constable after the post-mortem examination as per seizure list Exhibit 12. The PW9 also made query to the doctor who conducted the post-mortem examination about the possibility of the injuries caused to the deceased by such weapon, and he received the query report by Exhibit 3. The PW9 subsequently received the PM report and made prayer before the SDGM Keunjhar for sending the material objects to SFSL Rasulgarh, Bhubaneswar for examination, and received the CE report by Exhibit 15. On 27/2/2006, the officer in charge of Nayakot Police Station took charge of investigation, and on completion of investigation on 17/3/2006, charge sheet was submitted. The case was committed to the Court of Session, complying the due procedure, where the appellant was charged as aforesaid, and since he refuted the charges and pleaded not guilty, the sessions trial procedure was resorted to establish his guilt. In order to prove its case, the prosecution examined 9 witnesses, quote the names and what they have stated, and the exhibits are 15 that is to be quoted, and 2 material objects are there that is to be seen. The defense plea of the appellant is one of denial. The London Trial Court, after assessing the oral as well as documentary evidence on record, came to the conclusion that the death of the deceased was homicidal in nature, and the version of PW6 as an eyewitness to the occurrence was accepted, and it was held that the evidence is cogent, clear, trustworthy, and the London Trial Court has also accepted the version of PW3 and PW4, so also PW7. The evidence of the IO regarding seizure of the weapon of offense at the instance of the appellant was also accepted, and taking into account the C report, the London Trial Court came to the conclusion that not only there was a motive which is apparent from Exhibit 1, the written FIR, but from the evidence of the witnesses, it appears that the appellant carried the dead body and disposed of the same in the land of PW3 with the intention of to cause disappearance of the evidence so as to screen himself from legal punishment, and therefore the charges under section 302 and 201 of the Indian Penal Code has been established by the prosecution. Mr. Satyanarayan Misra, Land Counsel, appearing for the appellant, contended that though PW6 has been, the evidence of PW6 has been accepted as an eyewitness to the occurrence, but in view of the contradictions in his evidence, which has been duly proved through the investigating officer, it would be apparent that he is not an eyewitness to the occurrence, and for the first time he stated so in court. Therefore, the London Trial Court should not have believed the evidence of PW6 to be an eyewitness occurrence. PW2, where the occurrence took place, neither PW1 nor PW2 stated anything in that respect. And their evidence is also silent about the presence of PW6 in the house of PW2 at the time of occurrence. The Land Counsel further argued that even though PW7 has stated that he had seen the appellant carrying the dead body of the deceased, holding a bamboo lathi, but he has not stated to have seen the the appellant carrying the dead body from the house of PW2, and merely because bloodstained earth was seized from the house of PW2 by the investigating officer, and the appellant was seen carrying the dead body of the deceased, holding a bamboo lathi, and the bamboo lathi seized was containing human blood of group B, it cannot be said from such evidence that the prosecution has been able to establish the charge under section 302 of the Indian Penal Code against the appellant. And therefore, it is a fit case where benefit of doubt should be extended in favor of the appellant. Mr. Sonok Mishra Laden, Additional Standing Counsel, on the other hand, supported the impugned judgment and argued that even if, in view of the contradiction appearing in the evidence of PW6 to be actual seen the assault on the deceased by the appellant is not there, and but his presence at the spot, coupled with the seizure of bloodstained earth from the spot, that is the house of PW2, the version of PW7 to have seen the deceased being carried by the appellant holding a lathi, the notice, the finding of the chemical examination report about the human blood of group O from the lathi, and
Group B, sorry, man. Group B.
Sorry, group B, from the matching with the deceased, and moreover the seizure of the bloodstain, seizure of the lathi and axe from the at the instance of the appellant, which through which the injuries are possible as per the opinion of the doctor (PW8), it can be said that the chain of circumstance is so complete that it unerringly points towards the guilt of the accused, and therefore the London trial court is justified in convicting the appellant under section 302 as well as 201 of the Indian Penal Code, and therefore the JCRLA should be dismissed. Adverting to the contention raised by the London Council for the respective parties, let us first analyze the evidence adduced by the prosecution regarding the homicidal death of the deceased. We find that apart from the inquest report, the Dr. PW8, who has conducted the postmortem examination over the dead body of the deceased on 1/1/2006, has noticed the following injuries, scored the injuries, and on dissection he found so and so, and specifically opined that the cause of death was on account of the head injury, and all the injuries are antemortem in nature, and injuries number 1 to 3 might have been caused by weapon having sharp cutting edge, and injury number 4 being caused by blunt object. The in the cross examination, he has stated that injury number 1 is sufficient to cause death of the deceased. Therefore, the evidence of this doctor has not at all been cited in the cross examination, and the Learned Counsel for the appellant has also not challenged the same. Therefore, on the basis of the evidence adduced by the Dr. PW8 and the postmortem report marked as Exhibit 3, we are of the view that the Learned Trial Court has rightly came to the conclusion that the deceased met with a homicidal death. Now, coming to the evidence of the star witness examined on behalf of the prosecution, that is PW6, we find that he has stated that the deceased was his mother, and the house of PW2 was situated nearer to his house, and on the occurrence day at about 6 to 7 p.m., the appellant assaulted the deceased on her head by an axe in the house of PW2 and killed her. He has further stated that PW2 was his friend, and PW1 called the deceased to the house of PW2 where the appellant killed the deceased. And he further stated that apprehending danger to his own life, he fled away from the spot. In the cross-examination, the PW6 has stated that the appellant had no previous enmity with the deceased, and her mother used to take liquor for some time. Sometime her mother used to take liquor, and he had gone to the inside the house of PW2 when the appellant assaulted the deceased by axe. However, it has been confronted to the PW6 and proved through the investigating officer bracketry PW9 that he has not stated that PW1 called the deceased to the house of PW2, and there the appellant assaulted the deceased by means of an axe and killed her. Therefore, the material part of the evidence of PW6 that he had seen the appellant assaulting the deceased on his head by an axe and killing her is not there in the previous statement of PW6 recorded under section 161 CRPC. Moreover, PW1 has not stated to have called the deceased to the house of PW6. PW2. PW2 house. Similarly, PW2 has not stated that PW1 called the deceased to his house. Neither PW1 nor PW2 has stated about the deceased or deceased being called to the house of PW6 or about the presence of the appellant. Presence of the appellant in the house of PW2. Therefore, there is no material to corroborate the evidence of PW6. In view of the material contradiction in the evidence of PW6, his version as an eyewitness to the occurrence becomes doubtful. It is correct that the from the house of PW2, PW9 seized bloodstain earth and sample earth as per seizure list exhibit 9. And the evidence of PW7 to have seen the appellant carrying the dead body of the deceased holding one bamboo lathi has remained on second. But from the same and it has also been established that the weapon of from the lathi, as per the C report, human blood was found having carrying blood group of B, and the doctor has also find that the injuries sustained by the deceased were possible by the lathi, that is MO MO1 bamboo lathi, and the axe MO2. However, and when the PW7's evidence is silent that he had seen the dead body was being removed from the house of PW2, from the available circumstances, it is very difficult to accept that the prosecution has successfully established the charge under section 302 of the Indian Penal Code against the appellant. Therefore, the finding of the Lennon Trial Court that the prosecution has successfully established offense under section 302 is not IPC against the appellant is not acceptable. Now coming to the evidence of the charge under section 201 of the Indian Penal Code, since the evidence of PW7 has remained on second and the appellant was seen carrying the dead body of the deceased being armed with bamboo lathi, and the dead body was found from the backyard of the house of PW3 and PW9 has PW3 and PW9 has also stated in that respect. Therefore, we are of the view that the prosecution has established the charge under section 201 of the Indian Penal Code against the appellant beyond all reasonable doubt. The it appears from the records that the petitioner, the appellant, was taken into judicial custody in connection with this case since 31/12/2005, and he was not released on bail during trial, and during pendency of the appeal, he was granted bail by this court on 8/2/2012, and therefore he has already undergone the sentence which has been imposed by the Anand Trial Court for the offense under section 201 of the Indian Penal Code. And therefore the appellant shall not be taken into custody further. In view of the foregoing reasons the appeal is the conviction of the appellant under section Upper Lekhiwe 302 of the Indian Penal Code is set aside. The conviction under section 201 of the Indian Penal Code stands confirmed. The jail criminal appeal is partly allowed. Hello?
Obliged.
Fine. Yes.
I don't want to mention, my lord, a 399-402 allegation, your lordship has directed that matter to be listed a week commencing from 16th October. So already I have a filed memo that has not been listed. So already there is a direction the state government to verify the antecedent. That is the allegation. Co-accused person released on bail.
All right, we'll see. Yes.
I don't mention, my lord. Here in this case, the person is convicted for 20B2C. My lord, he is in custody since 2030. The held guilty for 10 years, and out of which he is already undergone.
Give it.
And that is the matter is in the list.
What is the delay? 200? It's a case of conviction. Where is the delay? Just a minute. Some report लिखाई जी कहीं फाइल बाहर कर देखे. Yes, we'll see, madam.
CSP bail malad adjourned to this, that has not.
And the matter is already in the list, the 158 number item.
Wait, yes.
Pardon me, my lord. Item number 235, 234, my lord. Kindly taken up today, my lord. This bail matter. Tomorrow.
We'll see that. Yes, next.
209, I have filed a IA for interim bail, my lord, for the illness of his mother, my lord, and obtain instruction, my lord. 234. 209, my lord.
Already instructions sought for.
No, my lord. First 209.
Mr. Das. 209. That is CRLA number 163 of 2020-22. Huh? So he has filed an interim application So listed for the first time on the ground of ailment of his mother. So you obtain instruction on the interim application. So IN number 2716 of 2023, this is an application for interim bail on the ground of ailment of the mother of the petitioner. Learned counsel for the state seeks some time to obtain instruction on the interim application. Please this matter give a date. Hello?
Item number 193.
Wait.
My lord.
Yes.
Item number 193. Father illness, my lord. Interim application instruction is of IN number
190.
193, my lord.
Is it coming for the first time or already obtained instruction?
No obtained instruction.
All right, same order. 193. Father's ailment. Instruction to be obtained. Mr. You have noted down, Mr. Das?
Item number 165.
Hmm?
Item number 165. Conviction 10 years, 8 years, and 2 months is in custody.
We'll see that also.
My lord, item 176, my lord. In this case, I have filed an application for interim bail due to mother's illness, my lord.
176.
My lord.
Instruction has been sought for.
My lord.
All right, call for that file and see whether.
176, madam.
My lord. 17 order ಆಯ್ತಲ್ಲ.
All right.
Yes.
Yes.
Item 105. 105 conviction for 10 years under section 304 part 2 and sentenced to 10 years. My lord. It is already custody for 10 years, 8 years. My lord.
We'll see the matter.
105.
My lord, that is out of list, my lord. We regularly listed for my orders, my lord.
Item 212 for consideration of bail, my lord. Conviction for 10 years. Is in consideration.
When matter reaches, we'll see that. Yes.
Item 222, my lord. I have filed IA for interim bail on the grounds of mother's illness, my lord.
222.
My lord.
So it has instruction. Instruction has first time it has come. 222. Okay, that is CRLA number 96 of 2023. And that IA is 2693 of 2023.
My lord.
Whose ailment you say?
Mother's ailment.
Mother's ailment. So instruction to be sought for.
My lord, item 103, my lord. That is the conviction for 10 years. With custody since 6 years, 4 months.
We'll take up this one.
What's the criminal of
Yes.
Item number 29. That is an appeal against an order refusing my representation prayer under 205. I am a senior lady doctor who has been charged under section 341, 323 and 3 of the SC/ST Act. And your lordship has also issued notice. My lords, the difficulty is that the special judge at Bhavanipatna is not granting accommodation for my appearance and is insisting that he will issue warrants. Can it be taken up today as the last?
We'll see that after this. Yes.
CRLA number 125 of 2020 for fresh admission, your lordship.
Give it.
Another is CRLA 131 of 2018 for bail, your lordship.
Item number 202, lordships. Interim bail. Last time call for this instruction.
Instruction niya aitla.
Aage.
The file ta dekhon ani kon asila. Yes.
Item number 115 and 133, my lord. There, my lord has directed me to supply the copy of the deposition. I have already served. Therefore, bail out of 10 years, about 6.5 years in court.
Yes.
Item number 239, my lord. The appeal for conviction that delays their, my lord.
230?
239.
It's a delay of 101.
Yes.
What is the sentence imposed?
14 years conviction. 14-year conviction.
14 years.
14 years.
Yes, Mr. Das. IA number. This is. What number mention kare?
239 item.
239. IA number 2732 of 2023. This is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 101 days in filing this criminal appeal, after hearing the learned counsel for both the parties, taking into account the averments taken in the interim application, and since it is a case of conviction of the appellant and sentence of 14 years has been imposed on the petitioner, I am inclined to condone the delay in filing the appeal. Accordingly, delay is condoned. Hard admit call for the trial court record. Interim applications for bail and stay realization of fine to be considered after receipt of the trial court record. Learned counsel for the appellant shall supply the deposition copies of the witnesses. Already annexed. You get that.
My lord, item 236 also.
Similar prayer, my lord.
There is a
Item-
delay in filing, my lord, may be controlled.
That is not there. That particular page has not been. That's why I have called for the file and see.
One, one.
Yes.
Item 240, my lords.
Yes.
Item number 33 has become infructuous, my lord. Already
Item number
33, CRL number 1186 of 2023.
CRL number 1186 of 23.
Yes, my lord.
It has become infructuous.
Yes, my lord.
All right. Take down this infructuous and accordingly disposed of. Yes.
Item number 240, my lords.
Please wait. Yes.
Lordship, item 241, Lordship. There is a delay of
240.
241. There is a delay of 116 days, Lordship.
It's a criminal appeal against conviction.
Lordship.
What is the sentence imposed?
Sentence, Lordship, 20 years and fine up to 15,000.
Okay, same order for the Hana. This is 200, 1, 2, 4, 5, 241.
41.
So delay condone, appeal admitted, Hana. Interim applications for bail and sterilization of fine to be considered. Right. All right.
Lordship, 242.
Yes.
There is a delay of 16 days, Lordship. 16. 242.
17 days.
17.
All right, same order. What is the sentence here?
Sentence, Lordship, 10 years and fine up to 5,000.
Delay condone. Admit 242. Hello? Admit call for the trial court record. Baki sabu jaha.
Lordship, another prayer, item 52. 5 years imprisonment.
50?
Item 52.
Yes.
There is a conviction of 5 years. So kindly take up this matter tomorrow.
We'll see that. Yes. Yes, Mr. Sarangi.
240 minutes. For condonation of delay.
Just
against conviction.
240 Tavarkala. 1244. Okay, the delay is 177 days. And what is the
counsel and 20 years is the conviction, my lords.
All right. 240, 240. Right.
Here, my lords, I have a small prayer because he is already state defense counsel and the only mother is available, no other member is there. I filed an application not on merit solely because he is in custody. So far as LCR is concerned, connected co-accused persons have filed appeal and LCR is before this honorable court. So it can be bail application be taken up any day next week.
Can you tell me the numbers of the criminal appeal which the co-accused persons have filed and that is
CRLA number 418 of 2023.
CRLA number
418 of 2023.
Yes.
And CRLA number 494 of 2023.
Okay. Since submitted that these appeals have been filed by the co-accused persons, the registry shall verify whether a trial court record has been received in those criminal appeals or not. All right.
Your Lordship, Your Lordship, item number 138 may
Yes,
be
but
taken up tomorrow.
we'll see that. We'll see. Yes.
Lordship, item 33, Lordship, my associate has given a wrong impression, Lordship. I could just not to want to appeal only. I could have left the chapter. That is wrong one, Lordship. Item 33, Lordship. CRLA 1186/2023, Lordship.
33 प्रकार infructuous
No, Lordship. Case is pending, Lordship. Just I want to not press the appeal, Lordship.
अच्छा
That is wrong, Lordship.
criminal appeal को not press करियो चाहूँ
Only not,
so
not
not
press,
press
Lordship.
all right not pressed
Lordship.
yes
My Lord, extreme sorry. One item 217.
Hmm.
217. My Lord also heard this matter. Can it be taken up either today or by tomorrow? Any day.
217
Sir.
bail paying
Sir.
bail paying तो
Bail paying.
wait we'll see.
Either today or tomorrow.
All right, we'll see that.
Obligation.
हाँ 230 ये पेज टा है ही नहीं बुझलो so it is 144 days so this is item number
236.
wait
20 years conviction.
so delay condone है ना admit call for the trial court record interim application you have filed any interim applications for bail all right. Yes. This item number this election item number 245 no
Pardon, my lord. Item on fresh admission criminal appeal against conviction under section 323.
दियोंतु memo दियोंतु
Only 7 listed at serial number 1.
हाँ
Serial number 1.
ठीक है रहो यार good a minute Mr. Misro
No.
start how much time you today you'll take
1 hour
1 hour so when so many learned councils are waiting can this matter be taken up at 2:45 or 3 o'clock
yes
so that we can take up the other
हमको दे करी
हाँ
तापर सेମାନଙ୍କୁ ନେଲେ ଦିଅ
नहीं
As your lordship
तांको संख्या टिके बेसी अछि तो सेहिति पय मु कहली आपण ସେମାନେ ସମସ୍ତେ ବର୍ତ୍ତମାନ ଅପେକ୍ଷା କରିବେ ମାନେ 3ଟା ବେଳେ ସରି ଯାଇଥିଲେ ସେମାନେ ଯେ ଯାହା କାମରେ ଯେ ଯାହା ଯାଇଥାନ୍ତେ ସେଇଥିପାଇଁ ମୁଁ କହୁଛି of course subject to you what you say
ମୁଁ ବି ପ୍ରପୋଜ କରିଥାନ୍ତି ଆଜି କାଲିଠୁ ସେଇ 3ଟା ବେଳଠୁ ନବା ପାଇଁ
ନାଇଁ ଠିକ ତ ଅଛି ମୁଁ ଆଜିଆ କଥା କହୁଛି ଆଜି ଆପଣ ପ୍ରଥମରୁ କରିଦେବେ କହୁଛନ୍ତି नहीं दरकार नहीं तेरा ये नहीं कि सर जो तो follow
mine
the election of the respondent Muhammad Mokim, which has been challenged by the election petitioner, was with respect to 90 Baravati Kotak Assembly constituency, number 1. It was held in the year 2019. And respondent Muhammad Mokim won the election with a margin of 3,827 votes.
Just a minute, Mr. Misra.
Now,
Mr. Misra, that order has been complied with, that 10,000.
Yes, that has complied. Memo has been filed, receipt has been filed.
As for the order dated, take down. As for the order dated 13/11/2023, the Mr. Vidyadhar Misra and senior advocate has produced the money receipt of rupees 10,000 issued by the High Court Bar Association relating to the cost imposed, with a memo which is taken on record at any other. Yes.
Respondent Muhammad Mokim won the election with respect to 90 Baravati Kotak Assembly constituency in the year 2019 with a margin of 3,827 votes.
3,827.
Election petitioner having lost the election filed the present election petition with certain prayers. The prayers are available to your lordship at page 20 of the election petition.
Election petition টা করুন। 20. Yes.
A, to declare that the nomination of respondent Muhammad Mokim having been improperly and illegally accepted, so the entire process of election so far as it relates to 90 Baravati Kotak Assembly constituency has been vitiated. Therefore, the result of the election of 90 Baravati Kotak Assembly constituency is materially affected and be declared void and set aside the same. Under prayer A, it has got 4 sub-prayers. A is nomination of respondent Muhammad Mokim have been improperly and illegally accepted. B, the entire process of election so far as it relates to 90 Baravati Kotak Assembly constituency has been vitiated. Therefore, the election of 90 Baravati Kotak Assembly constituency is materially affected. This is C. And D, the same is to be declared void and set aside. Kindly come to prayer B. Under prayer B, the election petitioner asserts
why it has been improperly accepted. A, the respondent has not submitted his nomination papers in prescribed Form 2B. This is one aspect with respect to Form 2B. Second is, has filed false affidavit in Form 26 along with nomination papers and has violated the election rules and acts. C, the election of respondent is void. And D, to direct fresh election with respect to 90 Baravati Kotak Assembly constituency. Here is also 4 segment, sub-prayers. First of all, I will invite your lordship's kind attention to the last sub-prayer under B, to direct for fresh election. In order to appreciate this prayer, your lordship has to go to section 150 and 151A of the Representation of People Act.
What are the sections you said?
150,
150,
150
and
151A, capital A,
RP Act.
RP Act.
Yes.
I am placing it, man. Subsection 1. When the seat of a member elected to the Legislative Assembly of a state becomes vacant or is declared vacant, or his election to the Legislative Assembly is declared void, the Election Commission shall, subject to the provisions of subsection 2, by a notification in the official gazette, call upon the assembly constituency concerned to elect a person for the purpose of filling the vacancy so called before such date as may be specified in the notification, and provisions of this act and rules and orders made thereunder shall apply as far as may be in relation to the election of a member to fill such vacancy. Subsection 2 is, if the vacancy so caused be a vacancy in a seat reserved in any constituency for the scheduled caste or for any scheduled tribes, the notification issued under subsection 1 shall specify that the person to fill that seat shall belong to the scheduled caste or to the scheduled tribes, as the case may be.
So this subsection 2 is not applicable here.
It is not applicable in our case. If we read subsection 1, it leads to the conclusion, if a vacancy is created or on account of anything as has been stated therein,
Declared void.
or declared void,
Yes, that is here. The prayer is there.
prayer is there. So here, if your lordship comes to the conclusion that in view of prayers A and B, if your lordship is pleased to declare the election of the returned candidate to be void and set aside the same, therefore it will automatically leads to allow, according to the prayer of the election petitioner, to direct for fresh election.
Okay. No, another thing just I want to know, just a minute. Is there any time limit prescribed either in the act or rules that
within which time it will be?
No, two things. That suppose, let us say, the 5 years, that period is to expire in, let us say, in month of February or March, let us say, and it is declared as void in month of January. Only 2 months left out.
Only 2 months.
So what would happen in such a case?
That has been specified.
Where?
Under 151A.
151A.
A
No,
section.
that is 151A. Okay.
A.
Asha. Please come to that.
Notwithstanding anything contained in section 147, 149, 150, casual vacancy with respect to assembly
150,
under 150. And section 151, a by-election, what your lordship is seeking about, for filling any vacancy referred to in any of the said sections shall be held within a period of 6 months from the date of the occurrence of the vacancy. 6 ମାସ ଭିତରେ ଆପଣ direct କରିବେ. If the prayer for to hold fresh election is directed by your lordship, that will be done within a period of 6 months by the election commission.
No, I'm going a step further.
Right.
Suppose it is declared void in January 2024.
Right.
And we are expecting the 5 years to be over by March 2024.
March or April.
There is if the election commission publishes any notification, then the time is to be given that this is to be date of election, this is nomination you have to file. So that period has to be at least given. So what I mean to say, that suppose an order is passed in so there is no chance of by-election, because even the provision is there. Since 2 months only remains, he
that
cannot
is why I am placing 151A. Proviso.
Yeah.
Provided that nothing contained in this section shall apply, what your lordship is seeking about.
Yeah.
A. The remainder of the term of a member in relation to a vacancy is less than 1 year. Your lordship got
which arises in this case also.
In this case also.
That means, again, another comment. That means what you say, that
our direction for fresh election,
so in that case, what will happen? Once let us say the court declares the election to be Mr. X as void, and nobody will be representing from that constituency, because it cannot be directed. He cannot direct to be held within that remaining period of 1 year. So how that constituency will be managed? Who is to represent that constituency?
Subject to 116A. Appeal ଯାଇକିରି ସେ ଯଦି stay ଆଣିଲେ, he will continue to 116A.
Okay.
Page 94. notwithstanding anything contained in any other law for the time being in force, an appeal shall lie to the Supreme Court on any question, whether of law or fact, from every order made by High Court under section 98 or 99. This declaring the election to be void and set aside the same will be covered under section 98 and 99.
That means, Mr. Misra, you mean to say that even if this court declares the election to be void, he cannot get the last relief which he has sought for in the second prayer. Okay.
In this regard, I will invite your Lordship's kind attention to section 116 capital B. Kindly note down section 116 capital B.
116.
116 capital B.
Yes.
And 116 capital C. दुईटा जाकर प्लस कर दे. 116 capital B है stay of operation of order of the High Court. An application may be made to the High Court to stay of operation of an order made by the High Court under section 98 or section 99 before the expiration of the time allowed for the appealing therefrom, and the High Court may, on sufficient cause being shown, and on such terms and conditions as it may think fit, stay the operation of the order, but no application for stay shall be made to the High Court after an appeal has been preferred to the Supreme Court. ଆପଣ ନିଜେ ବି ତାକୁ stay କରିପାରିବେ.
For giving them an opportunity to prefer an appeal and obtain an order.
When an appeal has been preferred against an order made under section 98 or section 99, the Supreme Court may, on sufficient cause being shown and on such terms and conditions as it may think fit, stay the operation of the order appealed from. Then subsection 3. When the operation of an order is stayed by the High Court, or as the case may be, the Supreme Court, the order shall be deemed never to have been taken effect under subsection 1 of section 107. And a copy of the stay order shall immediately be sent by the High Court, or as the case may be, the Supreme Court, to the Election Commission and the Speaker or Chairman, as the case may be, of the House of the Parliament or the State Legislature. First order ta bhi jibo setting aside, second order ta bhi jibo jodi apan stay debe किमा सुप्रीम कोर्ट भी देले से भी कम्युनिकेट हबो to the Speaker. 116C, procedure in appeal. Subject to the provisions of this Act and of the rules, if any, made thereunder, every appeal shall be heard and determined by the Supreme Court as nearly as may be in accordance with the procedure applicable to hearing and determination of an appeal from any final order passed by a High Court in the exercise of its original civil jurisdiction. And all the provisions of Code of Civil Procedure 1908 and the rules of the court, including provisions to the furnishing of security and the execution of court, including furnishing security and execution of any order of the court, shall so far as may be applied in relation to such appeal. Subsection 2 is, as soon as an appeal is decided, the Supreme Court shall intimate the substance of the decision to the Election Commission and the Speaker or Chairman, as the case may be, of the House of Parliament or the State Legislature concerned, and as soon as may be thereafter shall send to the Election Commission an authenticated copy of the decision, and upon its receipt, the Election Commission shall A. forward copies thereof to the authorities to which copies of the order of the High Court were forwarded under Section 160, and B. cause the decision to be published in the Gazette or gazettes in which the order was published under the said section.
One thing is that suppose an election has been declared void and application is made before the High Court to stay it because to prefer an appeal, stay operation of the order. The High Court no doubt has power, but let us say the High Court may refuse it, that you go and apply before the Honorable Supreme Court.
Another substantial point in favor of the person applying to the High Court will be twofold. That I seek to exercise my right of appeal to the Honorable Supreme Court.
Right.
And second, your Lordship may grant stay order, keeping in view that the whole constituency will go on represented.
Right. That is it.
That is more substantial. Because here is a personal right to appeal. And that is the rights of the entire electorate not to go on
nobody would represent him in this. But I mean to say, let us say the High Court refuses in the worst case, but they go to the Honorable Supreme Court. Once the matter is admitted, means stay is to be granted. Otherwise, there is no purpose. Because if stay is not granted by the Honorable Supreme Court,
these election matters are taken up with expeditious speed.
And otherwise, again, same thing will happen.
Same thing. The House will go, the electorate will go on.
Right. All right, you proceed.
Nine. So these are, so my first contention before your Lordship is, whether prayer of the election petitioner with respect to Form 2B or with respect to Form 26 or either of them is allowed declaring the election of the respondent to be void, his subsequent prayer to declare direct for fresh.
And that cannot be.
That cannot be.
Okay, that is your submission.
Mine.
Okay.
Because the most important feature is to be borne in mind of the court, either of the High Court or of the Honorable Supreme Court, that the whole electorate of the constituency cannot be let to go on unrepresented in the House for the remaining period. 2 মাস, 3 মাস, 6 মাস. This is one part. Then
Now, another thing, Mr. Mishra, just let us say here the election between the two persons is there. But suppose somebody has died. No, say represent ki kariyo say period re. Let us say it will take some time na. Upon the overnight he jivani na. So it may take 2 to 3 months time.
Yes.
So we can result ultimately counting allowed. Yes. So what happens? Is there any procedure that who is to?
No.
There is nothing.
No.
Interim arrangement ପାଇଁ କିଛି ନାହିଁ.
Interim arrangement.
Okay.
Death ଉପରେ ଅଛି ସେ provision ଟା ମୁଁ ଖୋଜିକିରି ଆପଣଙ୍କୁ କାଲି ଦେଇଦେବି କିନ୍ତୁ
ନର୍ମାଲ କୋର୍ସ ରେ ମନେକର ଜଣେ
ଅଛି ମୁଁ ଟିକେ ମତେ
ନାଇଁ ଠିକ ଅଛି ଖାଲି ଆପଣ କାଲି କହିବେ କିଛି ନାହିଁ ନର୍ମାଲ କୋର୍ସ ରେ ଜଣଙ୍କର ଡେଥ୍ ହେଲା ତ ଓବିୟସଲି ଇଲେକ୍ସନ ତ ହବ
ବୋଧେ 115 ବୋଧେ
କାରଣ ଏଠି ତ ଆଉ କିଛି ଚ୍ୟାଲେଞ୍ଜ କରିବାର ନାହିଁ ଏଠି କୋର୍ଟ ରେ ଇଏ ନାହିଁ
କେତେ ପେଜ
another so just keep in mind
ଆସନ୍ତୁ
ନାଇଁ ଏକା ଥରେ ଆନ୍ସର ଦେବେ 4 ବର୍ଷ ଟପି ଗଲା 4 ବର୍ଷ 2 ମାସ ଯୋଉ ଦିନ ହେଲା ସେଦିନ ଜଣେ ଏମଏଲଏ ଙ୍କର ଡେଥ୍ ହେଇଗଲା
ସେଗୁଡା ଅଛି 150 ରେ
50 ରେ କଣ କହିଲା ଯେ
casual vacancy in the state legislative assembly when the seat of a member
but again you have to keep in mind that 115(1)(a)
minor
15(1) ने कहला ना वर्ष भीतर जदी थिला इलेक्शन हबनी ताले सेही जो 9 मास धरी किनी से कॉन्स्टिट्यूएंसी रो कोन हबो
से कथाटा कहिछि परे
कोडी कोन कहिछि
150 पेज 114 के आसन
नो 150 मु जानली कैजुअल वैकेंसी हेले ये हबो बट अगेन थिला जे जदी दीज आर ऑल सब्जेक्ट टू नॉट टू स्टैंडिंग पर येटा ओवरराइड कला ना 151 हेला जो टाइम लिमिट टा फिक्स अप करिछि जे
सेटा वैकेंट रहबो पर द इलेक्टोरेट विल सफर
ओके
द इलेक्टोरेट विल सफर
कारण तार प्रोवाइजो रे कहिछि जे जदी लेस देन 1 ईयर थाए ताले हे परिबो नै ता माने जदी डेथ हला 4 इयर्स 3 मंथ जो एग्जांपल मु देली सेठी आउ नाही
की जने रिजाइन कर देला रिजाइन कर देला आइदर डेथ और रेजिग्नेशन
okay
setting aside void by the court is one thing vacancy will be created on death of the elected representative for that constituency the casual vacancy will be created on resignation of the elected representative casual vacancy will be created
but all the same if it is not to come within that void that means by way of election petition if it is for the other 3 reasons and that too that within that period of 1 year then what you say that it has to remain unrepresented till the next election is being held and a fresh representative will okay that's all right
ये ଏଇ କେସରେ ଆପଣଙ୍କର ମନେ ଥିବ ଯେ ତାଙ୍କୁ 3 ବର୍ଷରୁ ଅଧିକ କନଭିକ୍ସନ ହେଇଯାଇଥିଲା ମହମ୍ମଦ ମକିଂ ହାଇକୋର୍ଟ ବି ଷ୍ଟେ ଦେଲେ ଗ୍ରାଉଣ୍ଡରେ ଦେଲେ ଯେ ଇଏ ଯଦି ଜେଲକୁ ଚାଲିଯିବେ ସେ ଏଣ୍ଟାୟାର ଇଲେକ୍ଟୋରେଟ୍ ୱିଲ୍ ଗୋ ଅନପ୍ରେଜେଣ୍ଟ ସେ ଅର୍ଡରଟା ବି ଅଛି ଏକ୍ଜିବିଟ୍ ହେଇଛି ସେଟାକୁ ଦେଖ
कारण otherwise stay no deithile 2 years ye hala mane he would be okay
disqualified
right so
as far as practicable the act has taken into care all plausible aspects
that is the reason why the honorable Supreme Court has stated that within 6 months you try to dispose of
Mine,
that is the
mine.
yes.
ଆଜି ଏଇଠି ରହିବା କାହିଁକିନା ଆଉ ଗୋଟେ ଗଲେ ପୁଣି ଘଣ୍ଟେ
No, no, ठीक है. Just so today's summary of your submission is that even if the prayer has been made in A and B,
is
so far as
allowed.
the last part of the prayer of B is concerned, he
that cannot
cannot, that cannot be allowed. It is not possible to grant in relief because of these provisions under 151
Law
A.
doesn't provide.
Law doesn't. All right, tomorrow we'll continue.
Tomorrow at 3 p.m.
Okay.
କାହିଁକିନା ଏଟା ଟିକେ ପ୍ରେସାଇଜଲି ନ
ନାଇଁ
ଗଲେ
ନାଇଁ ଠିକ ଅଛି କିଛି ଅସୁବିଧା ନାହିଁ। November 2020, and it will be taken up at 3 p.m. है ना? Just so the pen drive for the application.
Weekly list, item number 1.
Please, Lordship. In this case, the appellant convicted under section 323 will be defended, and other offences has been acquitted, and the sentence has been imposed for 7 months with fine 1,000 rupees. Page 37, the 37.
कौन है जी?
Page 37 of my.
So it is 7 months and fine of rupees 1,000. In default to undergo RI for 1 month under 323. That is the only sentence that has been imposed on you, right? And you face trial under section 307.
294, 341, 506, and 307 that has been acquitted.
And you are on bail on during.
Bail.
All right. Admit. He was on bail granted. Sterilization of fine. AC टा बंद तो लगी.
Item 2. Item 3.
Convicted under section 354B, related with section 8 of POCSO Act. Operative portion, page 39.
Mr. Sandeep Raj Panda. What is this case, Mr.
3 years conviction, your lordship may kindly have a glance to running page 68. Towards bottom. It is a trap case amended.
Okay. 3 years, 5,000 fine. And in default to undergo RI for 6 months. Okay. But where is the learned counsel?
I will file my appearance by the end of December.
He was on bail.
Yes, written in paragraph 3.
The front page also indicates that.
Front page and also paragraph 4 may kindly be seen IA. 2741.
All right.
IA number 2741. Paragraph 4.
Admit call for the trial court record. Mr. Sanjay Kumar Das, Lenin. Standing Counsel for the Vigilance Department submits that he will file his appearance memo by
the end of December.
By end of December 2023. Considering the submission made by the Land Counsel for the so and so that the appellant was on bail during trial, there is no chance of early hearing of the appeal. Inclined to release the petitioner on bail, stay realization of fine. Yes.
Free copy of the order.
Free copy of the order.
Okay.
Item 5.
So this delay be condoned and Mr. Das na de devo and admit kar diyantu so and so be engaged, it is to be intimated to the
My lord, item number 6 and 8, I am for the appellant and I filed my power also. And my lord, kindly office may be directed to give me the free copy of the judgment since it is
No, you are Mr. Saroj Kumar Raut, right?
My lord.
So the Land Counsel, Mr. Saroj Kumar Raut is present and after so and so hearing, the Land Counsel for the appellants, also the Land Counsel for the state, since it's a case of conviction and sentence of so and so has been imposed, delay in filing the jail criminal appeal is condoned. Had admit, call for the trial court record. A copy of the judgment be supplied to the Land Counsel for the appellant. Yes, next.
Obliged.
Item 6.
6 gola apna.
Item 7.
7 সেমতি সেই শহরে যে order করলে আচ্ছা এইটা time রয়েছে, so it is only to be admitted and so and so is engaged as the counsel for this intimate. Yes.
Item 9.
Item 9
ନାହାନ୍ତି ପରା ଦେଶରେ।
Due to the illness of the both the witnesses, they could not be attending the court. So the date has been fixed to 15/12 manner. These two witnesses are eyewitnesses.
Uh,
302 case.
Yeah. Other witness out of 5 witness, 3 has already been examined.
No, that's all right. But they verified the state council and said that these are the two left out eyewitnesses. But of course, you are right that they had taken time to produce it. So and so, this one, so okay.
Lordship grant interim bail for some days, my lord. They it's 8/5/2021. They are in custody, my lord.
We'll see it on the 18th. We'll see. Lekhon. The Learned Council for the state has produced the written instruction received from IAC Kodala Police Station, wherein it is mentioned that the two eyewitnesses to the occurrence, namely Bashanti Naik and Rajeshwari Naik, could not be produced in court for recording of their evidence as on account of their illness. And the Learned Trial Court has fixed the date to 15/12/2023 for recording of the evidence of those two witnesses. Put up this matter on 18th of December 2023. If the aforesaid two witnesses are examined, in the meantime, Learned Counsel for the appellant shall produce the certified copies of deposition of such witnesses, giving copies of the same to the Learned Counsel for the state. Attorney Introduction.
The second sub item, my lords, may come along with the first, my lords. I am appearing for the
Put up this matter along with CRLA number 789 of 2023. All right.
Item 17.
Yes, Mr. Das.
Yeah, please, Lordship. The joint petitioner has been
Any other day, the notice and the CD has not been received, my lord. Okay, you have already sent it to the concerned. Yes, sir. The land and
they have
council.
not solved the
Extra copy.
extra copy. They have not solved.
You have not solved the copy. Supplied. How can it notice will go? The land and council for the state submitted that even in spite of the order dated 7/11/2023, the extra copy of the appeal memo along with the impugned along with the impugned order has not been served for issuance of notice to the informant. Land counsel for the appellant submits that he will supply the same by tomorrow. Okay. In case the land and council for the state receives the extra copy, he shall comply the order dated 7/11/2023 and produce the case diary, instruction about the criminal antecedent, if any, so also the written instruction about service of notice on the informant. Put up this matter on such and such date. Give a date. Yes.
Item 21.
Item 21, last second also directed to obtain the confirmation report whether the come or not. Confirmation report ଆସିଛି ନା ନାହିଁ ଜଣା
Notice ପାଇଁ
notice solve ହେଇଯାଇଥିଲା.
अच्छा.
Lordship, may I keep it to tomorrow? I have received the CD, but the confirmation I'm yet to receive.
He has instruction that it has already been solved.
Yes, your
But you are to say that.
My lordship.
So pass over कर दूँगी काली डकाओ.
Lordship.
Item 22.
May I please, lordship? No, kindly say. No. Last order kindly see the.
Compliance report ଆସିଲା.
Lords, we are yet to receive the complaints report.
No, you have already taken time. ଏଟା କଣଟେ?
Here, your lordship, the lordship had given a direction to the informant, to the IIC to make sure the informant is present before the trial court, your lordship, because the whereabouts of the informant are not known to us. So, your lordship, I pray for some more time because we have not yet received that instruction, my lords. Your lordship, order dated 17/10/2023, my lords.
I have said that one Lipun Patra and Joy Krishna Patra, they in respect of those two witnesses, summons has to be received, and then you are to ensure their presence on the date fixed. So after 17/10/2023, did your IIC Kundhiwala police station comply the order? Did he approach the London trial court for receiving summons of those two material witnesses to ensure their attendance?
Lords, we have not received.
No, ask him to remain present tomorrow at 2 o'clock through virtual mode.
I will, my lords. I will.
And whether he has complied with or not, so that we can ascertain.
Lordship.
Item 23.
23 lords kindly pass over.
That is appear the informant. I am for the petition.
You have received the
yes, case diary is there, your lordship.
So is it the first bail application or earlier rejected?
Second. Earlier rejected, who has withdrawn, your lordship.
That is in 6/35 of 2020.
My lord.
So since when you are in custody?
Custody since 15/12/2018, your lordship.
15/12/2018.
18.
You have never been released on interim bail?
No, as per my instruction.
What are the offences under which charge sheet submitted?
147, 148,
Just go slowly. Yes.
325,
Yes.
506, 307,
Yes.
302, 379, 149 of IPC, and section 31 RS and 32V of SC/ST Act.
So what is the trial position?
Trial position, my lord, altogether that 12 witnesses were examined, and I have given the deposition copy annexed. All
Is there any eyewitness to the occurrence?
yes, eyewitness. Informant is examined as PW10, and there is also injured eyewitness was examined as PW8. सेटा 134 पेज रे अछि informant, 128 पेज रे अछि injured eyewitness.
No, injured eyewitness is PW8.
PW8.
And the other witness
Informant.
Informant is also an eyewitness.
He is also an eyewitness.
He is PW10.
10.
So what they have stated?
They have not stated that I have assaulted the deceased.
ଆପଣ को implicate total କରୁନାହାନ୍ତି?
के भी कहि ना भी ना मन से स्पेसिफिकली ना कहिछन जे को माने मारिछन.
What is the name of this man? This is Chandan alias Devasis Das. Chandan Das, the first paragraph re na achi. I know the accused. Then
paragraph
today he has sought me the deposition copy and all the documents, lordship.
आगुरु दिया हैतला खाली deposition copy टा दिया नथला.
आज दिया हैला deposition copy टा 2टा बेले देले, lordship. तो काली की lordship में I prefer tomorrow.
PW8 paragraph 8 टा अछि जे से के मारिछि गेली स्पेसिफिकली 129 ने page 129 ne I along with Kasinath Shetty is the deceased, your lordship. Sorry, Loknath Shetty.
को paragraph टा पढ़ जाएंगे?
My lord, paragraph 6.
Paragraph?
Lordship.
Reading the evidence of PW8.
8, your lordship.
Yes.
Paragraph 5 and 6, the assaults part have been discussed.
I, along with my brother Anil Sethi and Amulya Sethi, tried to rescue our uncle. At that time, accused Pratap Jena, Nakada, so-and-so, assaulted my brothers, Anil Sethi and Amulya Sethi. So these are the two deceased persons.
No, my Loknath Shetty is the deceased person.
Achha.
Paragraph 4, your lordship, hears that is Mohan Das has stabbed Loknath Shetty. That is paragraph 4, your lordship.
Immediately I rushed to the playground of our village. At the playground I saw Prashant and Ajay got hold of. ये लोग डर ना कौन?
Chandan
alias Devasis. Prashant and Ajay caught hold of both the hands of my uncle Loknath, and Mohan Das was threatening by saying so and so, and thereafter dealt a knife blow on the left side chest of Loknath Shetty. Who is the deceased?
Loknath Shetty is the deceased.
That means so far as deceased is concerned, he was given a stab blow on the left side chest. That is the cause of death.
Cause of death is shock and hemorrhage due to penetrating injury.
Right, and that is attributed to Mohan Das.
PW10 भी say कुछ.
He is also another eyewitness.
Informant.
Who line dar gale?
Para 7.
Accused Mohan Das dealt a knife blow on the rib of the left side chest of my so-and-so, for which he fell down. Yes, what do you say?
I have no file, so I prefer.
You may not have file. And he is not supposed to supply you the deposition copy. You have a right to get the copy of the bail application. But since you are for the informant, you are to collect the deposition copy. Why he will supply? And moreover, if these are the two eyewitnesses, which the State Council has also seen, and it is the stab blow which has been given to the deceased, which resulted in his death, and the specific overtact has been attributed against one Mohan Das by two eyewitnesses. So the deceased, this man is not the author of that blow which has been given to the deceased, which resulted in his death. The learned counsel for the petitioner submitted that Lekhidev had so and so. Custody since 15/12/2018, and he has been charge sheeted under section so and so. He further argued that 12 witnesses have been already examined in the trial court, out of which PW8 and PW10 are the two eyewitnesses to the occurrence, to the assault on the deceased, Loknath Sethi. And both of them have stated that it is co-accused Mohan Das who dealt knife blow on the chest of the deceased, left side chest of the deceased, as a result of which she fell down on the ground. And no specific overtact has been attributed against the petitioner, and therefore the appellant, therefore the bail application may be favorably considered. Learned counsel for the state opposed the prayer for bail, so also the learned counsel for the informant. After hearing the learned counsel for the respective party, the period of detention of the petitioner in judicial custody, the progress of the trial so far, the fact that the two eyewitnesses to the occurrence being examined as PW8 and PW10 have implicated one co-accused, namely Mohan Das, to be the assault to have assaulted the deceased Loknath Sethi, and there is absence of any specific overtact against the appellant. I'm inclined to release the appellant on bail allowed. Obliged. This item is 23.
Item number 24.
May play loss. This is special appeal come in first time lordship notice required.
Right. So, Mr. Panigrai, what is the date of custody of the appellant?
Oblige. 28.
28 minutes on the last occasion, your lordship directed to take instruction whether notice has been sufficient or not.
Yes, Mr.
Lordship, we are yet to receive that instruction. Lordship, may grant me one more opportunity.
You have got the case diary?
Yes, case diary I have.
So, why don't you obtain instruction over phone today night so that
Lordship,
it can be taken
my
up
lordship,
tomorrow?
I will.
I'm just passing it over.
My
all
lordship,
right?
my lordship.
So, the rest of the matter will be taken up tomorrow.
29.
Kali ki naba? Kali se
I'll try to get it by
election petition ର hearing ଟା ଅଛି 3ଟା ବେଳେ ସେ argument ଟା ଯୋଉ ଚାଲିଛି ତେଣୁ 2ଟା ରୁ 3ଟା ଯାଏ ନିଆ ହବ ଏ matter ଗୁଡା